Good afternoon. You can be seated.
Also, keep your hands out of your pockets while you're up here. Quicker than I was with this.
Also use an ultimate.
I'll just go straight down the line. I'm just going to do the no attorney cases first. All right, good afternoon, everyone. I'm Judge Oberliesen. This is our arraignment or plea day docket. What I'm going to do is call each of you up. I'm going to start with the people who haven't been assigned an attorney yet, get through those quickly, and I'll start calling the public defender cases. What I'm going to do is advise you of what your charges are, make sure that if there's been an information or charging document filed in your case, and then if you don't have an attorney, I'll talk to you about if you want one appointed or are you going to seek private counsel. And then ultimately, your case will be set for a new court date, called pretrial conference, probably in October. All right, Jacob Edwards. All right, are you Jacob Aaron Edwards?
Yes, Your Honor.
All right, can you lift that microphone in front of you up just a little bit to make sure I can hear you? Just, yeah, better. There you go. All right, Mr. Edwards, you're here in 2025 CF 1611, charged with, is there an information in the case that's been filed?
Yes, Your Honor, we did file it on August 29th.
Copies of them all?
I do have the original. May I approach?
Yes. It's the original?
I believe so.
All right, Mr. Edwards, you're charged with domestic battery by strangulation, which is a third-degree felony. Do you understand that?
Yes, Your Honor.
All right, can you afford an attorney to represent you in this case?
I can't afford an attorney, but I would like a public defender.
You can afford one?
I would like a public defender because I filled out the application downstairs.
Okay, when was that?
That was about a couple hours ago.
A couple hours ago.
Yes, sir.
Assuming y'all haven't seen that yet. Let me just ask you a couple of quick questions. Mr. Maddox?
If I may, Your Honor, the state has informed me that Mr. Edwards' offer is going to be a PTI with plea. I'd be happy to speak with him, assuming the court is okay with that, about that offer. If the court would,
Pass.
we'll pass him certainly, Your Honor, but appoint me for the purposes of that until they can make a decision on the application if he doesn't want to take an offer today, Your Honor.
Okay. I'll go ahead and appoint the public defender provisionally for you. This is Mr. Maddox from the Public Defender's Office. He's going to explain to you what the state's plea offer is and discuss if that's something that you want to do. PTI is an intervention program that allows your case to be dismissed once you've completed the sanctions. So I'll let you go talk to him, but come back and talk to me before you leave. If you decide you don't want it, don't just leave the courthouse. Come on back.
Your Honor, there is one more issue. Ms. Rogers, the victim in this case, contacted Your Honor via email asking for no violent contact. In the meantime, I have spoken with her. She's here. So I would want to ask the court 1 minute to have her here, state that she's okay. She does want the no violent contact as a condition of bond.
Well, what if he takes the PTI?
It would be no violent. You
that she
prefer to
wants
do
no
it
violent
later?
contact. I think let's do it later to see what we're talking about as opposed to
Very well.
doing it for purposes of bond and then maybe talking about it for purposes of PTI.
Yes, Your Honor.
Very well.
But we'll address it all. I mean, this docket goes pretty quick. So go ahead and speak with Mr. Maddox. He may have to put you on hold for a minute while we talk to some other people.
Thank you.
Thank you, Your Honor. And provisionally was the word I was looking for. I just
Yes.
couldn't think.
Okay. Jesse Kellenberger. Jesse Kellenberger here. Don't have anything on Kellenberger? yesterday? Oh, hearing canceled. Not guilty by Mr. Switek. So his pretrial conference is going to be December 22nd at 9 a.m. All right, Leah Morris.
Judge, Ms. Morris's case was already no process.
It should be, we filed it, it should be in there, Your Honor.
I recall that from yesterday, I just didn't recall the name. All right. All right, Dion Olszewski. There's also to be Mr. Switek. That one's set for October 27th. All right, October 27th for Olszewski. All right, then next on the docket is David Steele. Mr. Sheik, that's a fugitive case. It looks like he was released on August 5th.
That's what I'm seeing here too, Your Honor, so the state will dismiss those charges.
All right, that'll be
That charge.
dismissed. All right, Cameron Reynolds. I have this listed as public defender, but it says misdemeanor, so is this a direct file from juvenile?
Yes, Your Honor.
All right, so this is 2025 CF 1494. Is there an information filed?
Yes, well, it was direct filed, Your Honor.
The direct file. You're right. This is leaving the scene of an accident with injury, which is a third-degree felony. Ms. Rivers?
Your Honor, we're going to enter a not guilty plea, request trial by jury.
All right. Any preference on the pretrial conference date?
Your Honor, I would ask to put it on the
12/22.
12/22 date, Your Honor.
All right, Mr. Reynolds, stay in touch with Ms. Rivers, your public defender. You'll come back for your pretrial conference date on 12/22 or December 22nd at 1 p.m.
Yes, sir.
All right, and I think the rest of them may be
That's fine.
PD cases.
You're good.
Gil Bell.
Inmate, Your Honor. And Your Honor, it's my understanding, in talking with both my office and the state, that a lot of case numbers are pretty wonky today or messed up.
Say again?
A lot of the case numbers today are messed up, either on the clerk's,
Your
on the
Honor,
docket or on the clerk's website, Your Honor.
If I may, because I believe the docket you're using is the one that was originally, is the older one, they have a newer one. It's
are the
only
newer ones?
cases on the newer one.
I think
So
we
you-
literally printed ours out at 4 o'clock yesterday.
Yes, Your Honor.
There was one after that?
Yes, we had about 16 names added
This docket?
to this docket, yes, Your Honor. And those are the ones that had some wonky cases. But all the ones you're calling on your docket, Your Honor, is from the older one, so they should be fine.
All right, I'm going to call through all these, and then we'll see who else is here, I guess. All right, go ahead.
Yes, Your Honor. This is Mr. Gil Bell before the court today, Your Honor. I'd enter a plea of not guilty on his behalf, request trial by jury in 15 days for any pre-arraignment motions, Your Honor.
All right, information filed?
My notes, this is a Miss Berrickman's case. She
Okay.
said she did file one count of L&L molestation.
Okay. All right.
Yes, Your Honor. that's
Preference
correct.
on court date for pretrial?
If we
October or
could, Your Honor, I
December?
would ask for the December date.
Okay. All right, I think we've talked about this before, that December 22nd is our Monday out of custody, and we're going to do the 23rd the following day is going to be our in-custody date, because the 24th and 25th are obviously holidays, so. All right, 12/23 at 9 o'clock for Mr. Bell.
Thank you, Your Honor.
All right, Johnny Ellisor?
Your Honor, this is Mr. Johnny Elliser before the court today. Your Honor, we'd enter a plea of not guilty at this time, ask for 15 days for pre-arraignment motions and trial by jury. I do anticipate getting some reciprocal discovery in this case over this day as well quite soon.
Information filed?
Yes, Your Honor.
Okay. All right. If you can just tell me your preference on dates as well, Mr. Maddox?
This one, Your Honor, could we put in October?
Okay. It's going to be October 27th at 1 p.m. Stay in touch with Mr. Maddox. He's your attorney, sir.
Yes, sir.
How do I say your last name?
Ellisor?
Ellisor.
Yes, sir.
I think I got it right. Okay. All right, Mr. Ellisor, we'll see you back on October 27th.
Yes, sir. Thank you, Your Honor.
Thanks, man.
All right, Samantha Forrest.
Inmate, Your Honor. Oh, she's out? Okay. Ms. Forrest? Your Honor, Ms. Samantha Forrest is before the court today, Your Honor. She's present and approaching. Your Honor, at this time, we'd enter a plea of not guilty, ask for 15 days for any pre-arraignment motions and trial by jury. The October date is fine for this case, Your Honor.
All right, information filed.
Yes, Your Honor, it was filed.
Yes, Your Honor.
All right. So that'll be October 27th at 1 p.m., Ms. Forrest. Come back on that date. Stay in touch with your lawyer. All right. Kimberly Layman.
Yeah, Ms. Layman's my client. Last I checked, I did not see where an information was filed. Does the state know if one's been filed?
There was, but I didn't have it in my packet, so I want to double check and verify that, Your Honor. Yes, there was one filed. If we need one, I can go print it out quickly, Your Honor.
Our clerk is going to print one out, Mr.
Oh.
Sheik.
Thank you, Your
Filed
Honor.
Monday. Is it just the contraband charge?
Yes, Your Honor.
All right, so it looks like it's just the one charge.
Yes, sir.
All right. Did you say you wanted October, Mr. Williams?
Yes, sir, Judge, let's do that.
All right, that's
That
going to
way,
be,
if we can get something that's amenable to her, we can go ahead and resolve it.
all right, October 29th, 9 o'clock.
Thank you, sir.
All right, Cameron Moffett. Give information on Mr. Moffett.
Yes, Your Honor.
Okay. What is your alphabet now, Mr. Williams?
H through O. It's pretty much always been that.
I know, it's just, all mine are listed as Miss Rivers.
Yes, sir, I've got a few of those.
Yeah, I mean, it seems like every one that's in your section.
Oh, no, I've got more later, Judge.
Well, that's what I'm saying, but she's listed on a lot of your cases. All right, Mr. Moffett, you're here charged in 25 CF 1508. Looks like robbery with a firearm and petty theft.
Yes,
Do you have
sir.
the information? Looks like it's in your file there, Mr. Williams?
Yes, sir, it
It's
has.
petty theft, Your Honor.
I'm going to enter a plea of not guilty on his behalf, request 15 days for any pre-arraignment motions, and demand trial by jury. Mr. Moffett, let's get you in to talk with me and go over your case. We already have discovery in on it, so we can talk about stuff.
You already have discovery, you said?
I believe so. Yes, sir.
All right, you want October or December?
I've seen the offer, Judge, and seen a little bit of discovery. I'm going to suggest the latter date, Judge.
All right, Mr. Moffett, it's going to be December 22nd at 1 PM.
Your Honor, I'm sorry, I would like to make sure that the other case that he has is also tracking with this, and that would be 24 CF 2479.
Is that a VOP or?
It was a PTI recall. He was on PTI when he committed this crime, so.
I don't think I have that one yet. Were we appointed on it originally, do you know?
Taking a look at it right now.
I don't know. I don't know if he had private counsel then.
24 CF 2479. Looks like he had Miss Dudley.
Ms. Dudley, you need to talk with her about that case, and then she'll figure out how to proceed from there. That may result in it ultimately coming back to me, but talk with Ms. Dudley about it. She's your attorney.
We'll see you back on December 22nd, 1 o'clock. All right, Jeffrey Pope. Information has been filed. Mr. Pope, you're here in 25 CF 1587, charged with robbery with a weapon, 2 counts petty theft, 2 counts resisting a retail merchant.
Your Honor, we're going to enter a not guilty plea, request trial by jury.
Court date?
October date.
All right. Mr. Pope, we're going to have you back October 29th at 9 a.m.
I'll be out to see you, okay? I got the discovery now. Okay.
Josephine Powell.
We'll talk. Okay. Your Honor, Ms. Powell is present.
Information has been filed. Ms. Powell, you're here in 25 CF 1619, charged with exploitation of an elderly person. Understand that? Okay. Rivers?
Your Honor, we're going to enter a not guilty plea, request trial by jury.
Court date? October or December?
We'll make it December, Your Honor.
Ms. Powell, come back on December 22nd at 1 p.m. Stay in touch with your lawyer. Emma Rossell? Rossell? This is 25 CF 1539, 1 count aggravated battery with great bodily harm or with a deadly weapon. Looks like deadly weapon.
Your Honor, we're going to enter a not guilty plea and request trial by jury. And information has been filed, I believe.
I see that. I'm reading them if I see that they're there, otherwise I'm asking. All right, which court date, October, December?
Your Honor, we'll try for October 29th, no, 27th, October 27th.
All right, is it Rosal or Rossel?
Roselle.
Roselle, okay. Option C, all right. Ms. Roselle, come back on October 27th at 1 p.m. Stay in touch with Ms. Rivers.
Yes, Your Honor.
All right, Parker Garea? Oh, ma'am?
No process filed, Your Honor, for Parker Gray.
Paper for you. Garea was Dalprost?
Mr. Sprouse, who has the joining cases, filed a no pros, but I don't see it in the clerk's site, Your Honor. So I will be able to announce on record that the state is dismissing the charges based on the victim's request.
All right. 25 CF 1529 has been dismissed by the state.
Thank you,
Becky
Your-
Hicks?
Did you say Hicks?
Hicks. Becky Hicks here. looking at Becky Hicks. She's not on the transport list or anything?
She was not on the jail list when I checked, Judge.
All right, State of Florida versus Becky Marie Hicks, 25 CF 1683, felony petty theft charge. I looked at her arrest report, lists her court date as today, 9/25/25 at 1:30, has the correct address as Crestview. State.
State would ask for a KPS, Your Honor.
All right, KPS, no bond for Ms. Hicks. If she shows up, please tell me.
Yes, Your Honor.
All right, Marquavius Jones.
Judge, I believe this was the case that the state was looking at sending down the county. I don't know what the status is on that.
Your Honor, may we approach?
Yes.
Things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays, 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Okay. You Mr. Jones? All right, Mr. Jones. From what I've been explained, this case may be sent down to county court as a misdemeanor, but they're trying to figure out exactly what the charges are going to be. In the meantime, the state has agreed to an ROR bond for you. The big thing is stay in touch with Mr. Williams, your attorney, so you know what days to be here. If it changes, I'm going to give you October 27th at 1 o'clock as your pretrial conference. But stay in touch with him in case something changes so you don't go to the wrong date or the wrong time or whatever it is. And then we might put out a warrant for you. So I'll make sure that that stuff happens because we don't want you picked up on something just because there was some miscommunication.
Yes, sir.
All right. 1027 at 1 o'clock for Mr. Jones.
There you go.
Stay in touch with your lawyer
And
for the
that's got
reasons
my
I've
number on it.
specified.
Thank you, Judge.
All right, thank you, Mr. Jones.
Yeah, just,
And that was based on the state's stipulation.
oh, that'll be today.
Okay, thank you.
All right. Dramus King.
Judge, somebody else wound up taking Mr. King's case over. Give me just a second, I can tell the court.
Oh, yeah, it's off this docket. It's still on mine.
Although I should have, Scott Klein's, we withdrew for
Charles
conflict.
Williams. Okay. Quick look at it. 2125.
Now, Judge,
All right, so it's with Mr. Williams, Charles Williams, not Jay Williams, and that's going to be October 27th at 9 o'clock for Mr. King. All right, Andrew Marshall. Andrew Marshall here.
It's on the jails list.
Andrew Marshall.
Judge, we withdrew on Mr.
Scott Kleins, okay. All right. Ending court date. Yes, it says Kleins. All right, that's going to be December 22nd at 9 o'clock for Marshall. All right, Bianca McDonald. This is 25 CF 1602. Information has been filed. 2 counts felony battery, 3rd-degree felony. Mr. Williams.
Judge, I'm entering a plea of not guilty on her behalf, 15 days pre-arraignment motions, and trial by jury. Ma'am, I'm going to give you a card. I want you to make an appointment to come see me, okay? And we'll talk about your case.
All right.
Oh, you do? Oh,
Let's
okay.
go October 27th at 1 o'clock for Ms. McDonald. Stay in touch with your lawyer, ma'am. They're going to give you a piece of paper. All right. That seems to be the end of my list, but obviously there's a lot more.
Judge, you should have a Sterling Kent.
Say again?
Sterling, Sterling, Kent, 25 CF 1733. Judge, when I checked, and information did not appear on the clerk's computer.
Give me the last name again. Kent, Sterling Kent. There it is.
K-E-N-T.
I found it. Information been filed, state?
No, Your Honor, it was added yesterday to the system, so we couldn't do it.
Has anyone seen Mr. Kent?
Judge, it's a new appointment for us, so I doubt he's even gotten our letter yet.
Can you come on up?
Mr. Kent, come up here, okay? Come stand over here on my left.
Yes, sir.
Okay. So Mr. Kent is present, Judge.
No information's been filed?
Not as yet.
They'd have an intent with that?
Your Honor, this is my understanding. The cases reached our office only last night. So one of our assistants was in the office until 8:30 trying to put them up into our system, but obviously I haven't had the chance to even look at it.
All right, we just want to set it off for the next arraignment?
That would be fine. I will definitely file it by then.
I don't think there's any choice, Judge.
All right, Mr. Kent, I'm going to have you come back on October 9th at 1:30. And by then, the state will have made a decision on if they're going to charge you and what they're going to charge you with.
All right, there's my card, sir. You need to make an appointment to see me. You want me to write that date down for you?
Yes.
Okay. There you go.
And they said for me to be here October that.
October 9th at 1:30. Yes, sir.
And then call.
Call the number on there, make an appointment to come see me.
Okay.
Okay.
Will do.
No problem.
Am I dismissed?
Yes, sir.
All right, I guess I'll just go back to the top of what I have with the new docket.
I've got a few, Your Honor, left, but if you could just pass them so I can speak with Mr. Edwards real quick.
All right, who do you have, Steve?
Your Honor, this is Lawrence Rudd. I found out about him yesterday when he made the docket that we were appointed to him. He's been in jail over a month, and we just now found that out. yesterday. The case number that was listed on one of the dockets goes to a William Ray. And speaking with Mr. Rudd, he has a violation of probation. He said he was arrested on it when he had his first appearance. I couldn't find any evidence of that. I do show his VOP cases saying that a VOP order commanding arrest was filed back on August 25th. So I need to verify if he's been arrested on his violation of probation or not, and if so, can we get that done?
And, Your Honor, to clear the record, the case for Mr. Rudd is 25 CF 1723.
Okay. I'm looking at 24 CF 2754. There was an order commanding arrest at first appearance on August 25th. But I can't tell if he's been arrested on that either.
No.
I'm not sure. He was sentenced back in June 2025.
What at this point needs to be done? Right, yeah.
I'm showing on the jail website,
That
it
he
has
was-
the VOP and says bond denied.
Yes. However, the clerk's website not showing anything, so
It
I
still
just want
shows
to get.
closed.
Yeah.
It's still closed. The VOP is closed on the clerk's website.
Right, but it needs to be open,
It needs to be open, yes.
To be reopened.
reopened, correct. Yes, yes.
Almost surprised on how much that makes a difference in how they do things.
And are we appointed to 24 CF 2754?
You all represented him last time,
Yes.
so I'll appoint the public defender in 24 CF 2754. Was an information filed in the new case?
Just this morning, Your Honor, because as Ms. Rivers said, we only were notified. May I approach?
That's a yes, if it was filed this morning.
I saw it.
You saw
All
it?
right, is that just 2 counts burglary unoccupied? Excuse me.
Your Honor, for 25 CF 1723, we're going to enter a not guilty plea, request trial by jury. For 24 CF 2754, I believe is what you said, we're going to enter a denial. We request both cases to track together.
What, the October date?
Yes, Your Honor.
All right, October 29th at 9 o'clock. Or both.
All right, you're good.
What else do you have, Steve?
Ms. Nixon, come on out, please. Love Nixon.
Judge, this is Love Nixon. Case number is 2025 CF 1729. She's got another case that's on the docket for originally it was 1027, now it'll need to be on 1029. I'm going to enter a plea of not guilty on her behalf. I checked, and the information was filed. Request 15 days for pre-arraignment motions and trial by jury.
Okay, looks like her other case, 25 CF 973, is already set for October 29th at 9, which will be the date for this one as well.
Thank you, sir.
Thank you, Ms. Nixon. We'll see you back October 29th.
All righty, ma'am.
Martin McDonald,
Yes, sir.
25 CF 1732.
Judge,
Information
Yes, Your
When
Honor.
I checked yesterday, I couldn't find any information on it.
Get that one in his hand.
Okay.
Are we gonna have a copy for them? I'm not gonna give them the original, but is this a copy?
This is a copy.
All right, give them that one.
Judge, if
All
you
right,
could.
it's a felony petty theft.
Okay. That's what I needed to know. I'm going to go ahead and give this to you because I'll get my own copy. And I'll come out to the jail and see you.
Is there any way Your Honor, can I speak?
You want to, but you have an attorney there speaking for you.
No, I've been in for 46 days and I haven't seen an attorney. But I have been trying to correspond with the state attorney's office in regards to
You're
my...
represented, sir,
I understand, sir.
but they won't respond to you and
Well-
only talk to you when you're in court.
Judge, we didn't know that we were appointed on him until yesterday. He's not even in our system yet. I discovered when I went through the docket, the amended docket. So I think I know where you're heading. Do y'all have an offer from Mr. McDonald?
Not at this time. I can review. If we want to put him to the end, I might get a chance to see, but I don't have an offer yet.
Can I ask the court a question? I was wondering if maybe, if possible, respectfully, to give me a downward departure on this, maybe with time served with the 46 days I got in.
You score prison?
I don't think I do, sir.
Well, you asked for a downward departure, that's why I asked.
I might right on the verge of it, but I don't think I do, but
Well,
I don't know if that...
I'm looking you up just in Okaloosa County. You seem to have quite the record, Mr. McDonald.
Yes, sir, but a lot of my record was not adjudicated guilty on a lot of it, the serious charges.
I can still consider those, but until they make an offer, otherwise you'd have to plead straight up, and I can do anything up into including the maximum, which would be 5 years in state prison.
I understand that, sir.
I'm not going to negotiate with you, Mr. McDonald. That's for you and your lawyer to do with the state.
So we can put me off until the end, like we said?
We can try that. The state's under no obligation to give you a plea offer today.
I understand. Well, I would appreciate it.
Mr. McDonald, do you want me to finish or no?
Yes, sir.
They can look at it. If they want to give you a plea offer, they can certainly do that today, but it may not happen. But we'll pass you till later.
Okay, thank you.
All right, thank you. Who's that? Settles. I'm looking at my docket was printed, this is the one that says 11:42 on it yesterday. Oh, no, that's 11:22. Okay, never mind. 2 days difference. Maybe I grabbed the wrong one.
Not today. Well, we've got to figure out about this new case. Your Honor, the docket lists Melinda Settles. When I went online and pulled up the case that's listed under Melinda Settles, there was actually, no ma'am, there's actually another person's information attached online, and that was Pedro Fuentes. Okay, battery upon a jail detainee. All right, Your Honor, we're going to enter a not guilty plea, request trial by jury. She is already on the October docket. We're going to ask to put her on the October docket.
And Your Honor, to perfect the record, it's 25 CF 1745.
Well, I'm looking at 25 CF 1745, and as Ms. Rivers said, the first appearance paperwork that's in that file is for someone else.
Victor Fuentes.
Pedro Fuentes.
I'm sorry, Pedro Fuentes. And it says, for him, it says 25 CF 1729.
I did battery on him.
No, ma'am.
No, ma'am.
We'll see you back on October 29th, 9 o'clock, with your other case.
With what other case?
Let me look it up.
The one with the cover over the car?
So I'm not getting out?
No, I'm not getting out.
So the cover over the car is October 29th?
I don't see another case number, is it?
Your Honor, she does have another case with the court. That was originally what she was in jail for, is a burglary case. and criminal
Miss
mischief.
Miss Settles.
I was going to wash the car.
No. And Your Honor, she is currently, Dr. Sheehan did indicate that she met with her last week. I did speak to Dr. Sheehan on Monday, and a report is forthcoming.
All right, I'm looking at 25 CF 1490 and 1486.
She has one case.
And numerous misdemeanors open, too.
Can I get out in October?
It depends on the evaluation.
What evaluation?
Dr. Sheehan.
Sorry, wasn't information filed in this case?
Yes, and I gave it to the defense.
All right. So everything will go to October 29th, 9 o'clock.
October 29th. This is the information, okay?
Schoffner. Ronald Schoffner, 25 CF 1744.
Your Honor, we were made aware yesterday that we were appointed to Mr. Schoffner back in August. Mr. Schoffner has been in jail for over a month without us not having any knowledge of his presence. I did find out yesterday when it was on the docket. I did meet with him, and I believe there is also an issue with the case number listed on one of the dockets for him as well. The 25 CF 1751 goes to a Trevor Flint. I believe his case number is 25 CF 1740, maybe 44. Because the state didn't know about your case either. So they can't make the offer. We're going to put you on for October 9th. For that date as well.
When I pull up 25 CF 1744, it says Mr. Schoffner, but the paperwork for first appearance is for a Stephen Ellis. Who do I need to talk to about this? This is out of control. I mean, we've got people in jail for a month or more who had a public defender appointed in their first court date, the day after they got arrested, and no one's telling the public defender about it, and the paperwork is all wrong.
Your Honor, some of mine are 8/18 where they were appointed, and others are at the end of the month that they were appointed back in August, but they're both back in August.
I know it says the case was filed on 8/18, but the paperwork is from a first appearance on August 24th for someone else.
She's not willing to make an offer today. Or she, so best we can do is the 9th, which is his very next court date.
Oh, so he's 1751?
And 1751 goes to Trevor Flint. So I did
You
file
have
for bond reduction.
1744, Your Honor? Is
I have
that what you
1744. That's the one I've been looking at that says Stephen Ellis on
Are
it.
you looking on the clerk's or on the?
Looking on my site.
Yeah, I
so-
think that might be it. The clerk's site was, the new clerk's website was wrong on their numbers. We've now, I think they've now updated them on that one since then. I noticed that with the settles, looking up for that defendant. I haven't verified with this one.
I believe I did file a bond motion under the 1744, so.
I saw that. It's up for
It-
2 weeks.
It may be under the wrong case number as well. I would ask that I provide a copy of my bond motion to the court through the manner that we've been doing here lately, and that he have bond reduction hearing on October 9th, regardless of what case number it is.
If you could send it to me as well, the motion, because I don't have it. Yeah. Oh, okay. Or, that's
We had
fine.
notice of hearing that you sent in today for the bond reduction, but I don't see the motion for bond reduction in the file. Maybe it just hasn't been processed if that was just filed today as well.
It was all just filed today, Your Honor. But I'll make a note, Ms. Leone, to send you
Was it
everything.
information filed?
No, I haven't
You just
filed.
found out about it yesterday?
Yes, actually, this morning, because it was up past office hours when they added it.
What is your notice of hearing? What time does it put it for?
9 a.m.,
O'clock?
9 a.m. on October 9th.
I'll do-
I can do earlier if the court has any availability. On Wednesday?
9 o'clock?
I'm sorry?
Earlier than 9 o'clock?
Yes, Your Honor. My client just wants, the opportunity.
I mean, the issue is if he's been in since August 18th,
Yes, he is entitled to
There's no
a release.
information.
He is entitled to a release.
file your motion.
Okay.
I'll entertain it as soon as it comes across my desk. And certainly, I'm not putting any blame on the state in this. If you just found out about the case this morning, that's been pending for 5 weeks or more, we're coming across some deadlines to file informations. All right, I'm going to put it on October 9th at 9 o'clock for the bond hearing. We'll just handle an arraignment if an information's filed by then or prior to then. But I'll also entertain any motions, assuming you're able to file it in the right case number, Ms. Rivers. But send a copy to my office.
Yes, Your Honor.
All right, thank you, Mr. Schoffner. We're trying to figure it out, but I'll see you back on October 9th unless an earlier hearing's set.
It'll be next week. Your Honor, sorry.
All right.
Your Honor, this is Davin Smelly. He is similarly situated. I found out about him yesterday. He has been in the Okaloosa County Jail since August. We were made aware of his presence in the county jail yesterday. We got notice of the case yesterday. And I did
You know what
immediately
his
go out.
actual case number is?
I think the case number might be okay for him.
I mean,
I think
'cause-
this one might be correct, Your Honor, 1730.
So that's why I was giving it to her.
So he was appointed a public defender on August 22nd at first appearance.
Yes, Your Honor.
You all were notified of that yesterday.
Yesterday, Your Honor.
Do we not have an information file? Then?
No, Your Honor. Again, I learned of this case actually this morning. Yeah, no. He scores prison. Just with that.
She said you scored prison.
I mean, it's pretty clear we're going to have to all sit down and have a meeting. I don't know if you want to get
Yes.
Ms. Herndon and Mr. Russell and whoever we're going to talk to from the clerk's office and see what the problem is. But we can't just keep people in jail for 5 weeks and not even tell their lawyers that they're there.
Certainly, Your Honor.
This is, I would say unacceptable, well, that doesn't go far enough. All right, I'm going to set them for 10-9, but again, I'll entertain any motions that are filed between now and then.
I did file it this morning.
I keep saying that, and I know Ms. Leone, I know it's not, if y'all just found out about it yesterday, you can't do an investigation, you can't make a charging decision, but, you know, the rules are the rules, so I don't know how y'all are gonna handle it, but this might require some sort of meeting of the brass of all of our agencies or offices, so.
Yeah, I wonder, Your Honor, if the clerk has an idea as to what's going on, because it certainly doesn't depend on the attorneys. I can tell you that my office, when it comes to new cases, can have a direct link with the clerk's side. So every day, every hour, the assistant check for new cases to be added. And for instance, all those cases were never added until yesterday, so we didn't even know about them.
I guess I'll try calling the ones that are on this paper docket I was handed. I've got Adolfo Aguilar Cosino. All right. Are you Mr. Aguilar Casino?
Yes.
Okay. Are you represented?
Not today, sir.
Are you going to hire a lawyer?
Yes.
Is there an information file?
Yes, Your Honor.
All right. So it's DV battery and
Yes, Your Honor.
communication.
Yes, Your Honor.
So that's, what, a third-degree felony and a first-degree misdemeanor? You understand that, sir?
Yes, Your Honor.
I'm going to enter a not guilty plea on your behalf. We're going to set your case for a pretrial conference on August, I don't know when that, I'm saying August. October 27th at 9 a.m. Obviously, if you're going to hire a lawyer, it'd be good to have them there at that date.
With you, Your Honor.
All right. Any questions?
No questions.
All right, thank you. All right. Roy Williams. Yesterday.
Your Honor, Dustin Durrell filed a notice of
That's it.
appearance on September 23rd.
All right. All right, let's put Roy Williams on October 27th, 9 a.m. Destiny Baker. Maddox.
Yes, Your Honor.
Y'all have an
Baker, present,
information,
approaching.
information file?
Yes, Your Honor. It's as charged on there.
All right, so Ms. Baker, you're charged with 2 counts of criminal mischief, third-degree felony.
Yes, Your Honor. At this time, we'll enter a plea of not guilty. Ask for 15 days for any pre-arraignment motions and trial by jury.
All right, you want the October date?
Yes, Your Honor. That's fine.
All right, that's going to be October 27th at 1 p.m., Ms. Baker. Stay in touch with your lawyer and see you back on that date.
Thank you.
All right, have a good day. Stephen Ellis.
Your Honor, Mr. Ellis is present and approaching. Unsure about the status of the information, Your Honor.
We just filed it this morning. It's one of those I got.
Yeah. Do you have a copy of it for
May
them?
I approach? I just have one.
Charged.
As charged, so it's 2 counts of possession of a weapon or ammunition by
It was charged with 1 count only, right,
One count.
Mr. Maddox? Yes.
Can I see it real quick? All right, so it's possession of a firearm, ammunition, or electric weapon by convicted felon. Second-degree felony. Do you need this back?
No, Your Honor. I'll leave it for the court.
My docket says possession of a weapon by a Florida delinquent adult felony.
Your Honor, we'll enter a plea of not guilty. Ask for 15 days for any pre-arraignment motions and trial by jury.
October 27th, 1 p.m., Mr. Ellis. Be back on that date. Stay in touch with your
Says I
lawyer.
have a date of 25th.
27th. You got another case? Does he have another case, Your Honor? Just want to make sure he's
I'd
not
love to know.
getting confused, the date's getting
I
confused
went
here.
online, it said the 25th.
Okay, well, we'll check.
Hold on.
Of course, today is the 25th of September.
Oh, it's the 25th next month.
Okay,
25th of the next month would be a Saturday.
that's, yes. But, I don't know. Stranger things have happened.
The past 5 minutes they have. I don't see another case for Mr. Ellis.
Okay, come back on the 27th, sir.
All right.
1 o'clock. Thank you, Your
All right,
Honor.
Bill Fleming?
Fleming? Okay. Your Honor, Mr. Fleming is present and approaching. Unsure about the status of the information.
Mr. Sheik has it.
Yes, Your Honor. We filed on counts 2 and 3 in this one, Your Honor.
I'm sorry, say that again, Mr. Sheik.
We filed on counts 2 and 3, Your Honor.
Your Honor, at this time, we'll enter plea of not guilty on those counts. Ask for 15 days for any pre-arraignment motions and trial by jury.
All right, Mr. Fleming, come back on October 27th at 1 p.m. for your pretrial conference.
We got to down it. Bed, just, I mean.
Write the date down? Sure.
My calendar's kind of.
You're fine, man. October 27th at 1 o'clock. All right, sir.
All right, Pedro Fuentes.
He's an inmate, Your Honor. Same thing as Miss Rivers. We were just
He's not even
notified.
transported because we didn't know he had court, right?
That wouldn't surprise me either, Your Honor, unfortunately. I'll also file a motion if we need to, Your Honor.
State has filed an information this morning, Your Honor.
Oh, okay.
Is it Fuentes? Is there a T in there?
I believe there's a
On
T
my
there,
docket,
Your
there's
Honor.
no T.
I have Fuentes.
Yeah.
Well, maybe they have the name confused, Your Honor. It's written as Fuentes on the first appearance paperwork.
Yeah, that's what I saw. That was filed in someone else's file.
Okay. Do we want to bring out the Mr. Fuentes and see if this is his case? Oh, okay, that's what you're
He
saying.
wasn't
Okay, there's not
transported.
two. Okay, I
Yes.
see.
Is it Pedro?
Pedro, yes.
I just wasn't sure. Yes, so we had it as Fuentes, so I think that's the same one, Your Honor, with a T.
When I put in the number, that's when we get to missettle again.
And I have 1729, Your Honor.
729.
Yeah, for the,
745 written on my dummy file here, but I'm not.
Yeah, that's the
That
one
was
that's
the-
actually
Okay.
settled.
Okay.
See if we can get him here.
That's fine, Your Honor.
Unless you just want to, well, the information.
No,
is
I'd
fine.
like to, if
You'd like him here?
possible. Yeah, I'd
That's
like
fine.
to make contact with him, Your Honor, since I haven't. At least the court could inform him as to what happened, and he'll be aware of the situation. Thank you,
As
Josh.
soon as I find out what happened, I'm going to be happy to explain it to people.
Well, let's go ahead and give him a court date, though, Your Honor, of the 27th, just to get it on the books.
Well, if he's in jail, it'll be the 29th.
29th, apologies.
October 29th, 9 o'clock for Mr. Fuentes or Fuentes. See if we can get him here in the meantime. All
Appreciate
right.
that.
Is it
Then I have Brandon Gary. That's the last one I had, Your Honor.
Brandon? I've got Braden.
Oh, Braden. No, that's
Okay, it is-
that's my eyes playing tricks on me that time.
Okay.
Braden Gary. Information followed, Mr. Sheik.
so I left the information with my secretary over lunch.
Yeah.
She was supposed to email it to me as soon as she gets done, so if
Take
it's
your word
not
for it.
filed, it will be filed very shortly, but I do not have a copy of it right now.
All right, I'll take the state's word for it on that one, Your Honor. We'll enter a plea of not guilty, ask for 15 days for any pre-arraignment motions and trial by jury. Assuming something strange happens with the information, do we want to just put them on October 9th just to be safe?
I think October 27th at 1 o'clock.
Okay.
All right, but follow up on that, Mr. Maddox, to make sure that it's filed.
I will, Your Honor.
And Mr. Sheik.
Yes, Your Honor.
Jenna Rogers.
Your Honor, we found out yesterday that we were appointed to Jenna Rogers, 25 CF 1731, and the co-defendant Michael Vega, 25 CF 1742. We have filed a motion, notice of conflict on Ms. Rogers' case, 25 CF 1731. And I'm not sure about the 1742, if that case number is correct or not. But we did file during lunch, I think, the motion for conflict.
Got Vega is 1742 and
Okay.
Rogers is 1731.
Okay, yes,
I mean, that's what the paper docket says.
right. At any rate, Your Honor, I can't represent both. We did file a motion. It'll be filtering through your office
Hold
shortly.
on. This says that Vega is 1726.
Yes, Your Honor, that's why I made the comment. I didn't think that was correct.
All right, so you're withdrawing from Rogers?
That's correct, Your Honor.
All right, if you just get me an order appointing the Regional Office of Conflict Counsel. Ms. Rogers, the public defender can't represent both of you since you're co-defendants, so you'll be represented by the Regional Office of Conflict Counsel. Mr. Klein's, who is from their office, is not here right now, but if you can contact their office, you'll be getting an order, a copy of it, that says that he's been appointed as opposed to the public defender. But I won't be able to sign that until, number one, I get it, and two, have a chance to do it, so. But I'm going to give you, in the meantime, I'm going to enter a plea of not guilty for you, give you October 27th at 1 o'clock, or I'm sorry, 9 o'clock.
I can write it down there for you, here.
All right. Dean Sheerbaum.
Mhm.
Schierbaum. Schierbaum. Rivers? Any contact?
Your Honor.
Did you even know you were appointed to him?
Your Honor, I was made aware yesterday, and I know I have not met with this person.
You're looking for a case number, Your Honor?
I'm looking for, yes, what's the case number? Because the one I have, when I click on them, it goes to Destiny Baker.
I have 1743, Your Honor.
I'm just trying to check to see if they gave him a court date or not. Sorry, Ms. Rivers, you said you had no contact because you didn't know about it until today.
That's correct, Your Honor.
Looking at his arrest paperwork, that shows today's date, 9/25/25 at 1:30. Y'all find out information?
Yes, we did. We just gave it to the defense, and it's as charged, Your Honor.
Turn is I've got no way to give him a court date. You haven't had any contact with him. Let's put him on. Did you enter a plea of not guilty, Ms. Rivers?
Your Honor, I'm entering a plea of not guilty and requesting trial by jury.
All right, I'm going to give you all October 27th at 1 o'clock. Yeah, I'm sure your office will do your best to find
Yes, Your Honor.
Sheerbaum, but he's got a bond, but I'm not going to capious someone when, who knows if they even told him what day to be here or that he was appointed a lawyer. And he was appointed a lawyer on August 31st, and they found out about it 4 weeks later. All right, James Simmons.
I believe the case number is correct in this one, Your Honor.
I don't even think we can say that because I'm looking at things that gives two different case numbers
Yes,
for each
Your Honor.
person almost.
I have 1734 as being correct.
That's what I have.
And I just handed the defense the information that we filed today, Your Honor.
And I will be entering a not guilty plea, Your Honor, requesting trial by jury. I was made aware of this appointment yesterday.
October 27th, 1 o'clock. Ms. Rivers, if y'all could try to keep track of the ones where this has happened, so we have a comprehensive list,
Yes, Your Honor.
not only for purpose of figuring out what happened, but also to make sure y'all know who to try to find. I just don't want to issue, capious for people who have no idea what they were told when they left the jail.
Yes, Your Honor. All right, that's the end of this list. Your Honor, we also have Michael Vega,
Oh, I'm sorry, I skipped that one.
25 CF 1726.
That's the
Co-defendant.
Rogers.
Yes, Your Honor. Mr. Vega is present and approaching. We're going to enter a not guilty plea, Your Honor. Not guilty and request trial by jury.
August 27th, 1 o'clock. Or August, why do I keep saying August? October 27th.
Thank you, Your Honor.
You're at 1 o'clock. She's at 9 o'clock because you have different agencies representing you, different lawyers. See you back on that date. Jeremy Holly, is that yours?
Yes, Your Honor. Hey, Mr. Holly, come stand on that blue square right there.
We have a case number on Holly?
I do, Judge. It's 4625-1021. And And what we've entered into is a deferred prosecution agreement. I'll tender the original to the court. That'll need to be agreed to this 25th date of September. 25th, is that your name? Yeah, 25th date of September 2025.
And Your Honor, this is based off of statements and requests made by the victim.
We took her deposition a couple of days ago.
For prosecution, is there anything else holding Mr. Holly in the jail?
Not that I'm aware of, Judge. The agreement does call for an ROR bond.
According to the deferred prosecution, he'll be released on his own recognizance. Case will be taken off the docket.
Thank you, Judge.
Thank you.
Judge, do you want to give a control date on the DO? I don't know if y'all do that over here or not.
I mean, I gave it to the clerk, so what would we be waiting for? I'm not trying to sound like I'm asking a sarcastic question or anything. I'm really asking.
On a 6-month DPA, we used to do a 6-month date, but that's all right. Mr. Holly, you just need to be sure you stay in touch with me and make sure you get that anger management class done. And I'm going to file a copy with the clerk, and I'm going to suggest you give me a copy also.
Yes, sir.
Okay.
All right, thank you.
Thank you, sir. All right. We're probably going to need just a couple of minutes, Judge. The original officers was for community control, but her plea was to possession of paraphernalia. So we can't do community control on it. The court may know off the top of your head, otherwise I'll check. What was suggested was drug offender probation, which is a little less restrictive, but I'll need 5 minutes to explain that to her. And I want to check real quick and make sure that that's also is an option for a misdemeanor. I've just not had it come up, Judge.
I'm seeing a head shaking from probation.
Typically, a verdict in probation is reserved for felonies. Misdemeanor probation is just misdemeanor probation.
Then what I'm going to suggest is we just reinstate with the that class that they wanted her to do, the FACE-IT course. Are you willing to do that?
I'd like to have a moment to talk to probation about that.
Okay, so ma'am, we're going to, do we have other cases,
I have one
like
recall.
motions this
Yeah, we're
afternoon?
going to be here a while.
All right, then. We'll bring you back out in a few minutes.
All right, is there anyone else who thinks they're on the 1:30 arraignment or plea date docket? Well, I'm just trying to focus on people who are actually on the docket.
Judge, I'll take a minute.
I just can't hear, and said a friend of hers had someone on the docket.
I'll talk to the judge.
I have just one recall, Your Honor, Mr.
Sure.
Edwards.
Edwards?
Yes, Your Honor, Jacob Edwards.
Jacob
He was
Edwards?
called earlier, provisionally appointed public defender, Your Honor.
Okay. Or we've got Fuentes as well, or Fuentes.
Oh, good, okay. Your Honor, Mr. Jacob Edwards on recall here. Your Honor, the state's offer was a pretrial intervention agreement with a plea. It'll be for 10 months. It'll include batter's intervention program, court costs. We're going to call the victim up here in a second, but no violent contact with the victim. And it'll be a PTI with a plea to a misdemeanor battery, Your Honor. State's not able to prepare that today, but certainly we'll be able to by 10/9, and we will enter that plea on that date.
10, it'll be October 9th at 9 o'clock, but do we want to have the victim give testimony now?
Please, for changing the
Okay.
contact.
All right, come on up. All right, can you raise your right hand?
Same.
Do you you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? And your name, please?
It's Kristen Rogers.
Rogers, okay. Go ahead, Ms. Leone.
Do you know the defendant, Mr. Edwards?
Yes, he's my fiance.
Do you live together? Are you asking the court to change the no contact to no violent contact?
Yes.
Are you afraid of the defendant? No. Do you have any concern about your safety with the defendant? Other questions, Your Honor?
Just one from defense, Your Honor. Are you okay with him returning to your residence?
Yes.
Okay. Your Honor, at first appearance, he was also ordered not to go back to that residence. Defense would ask the state to stipulate to changing that as well.
Yes.
I'm looking at the first appearance paperwork. It says victim wants contact upon release. And it was still checked. No contact, no going to the residence.
I've seen it on occasion, but it's rare. Sometimes the judge will make a determination based on other factors.
Ms. Rogers has testified under oath that she wants contact and for him to be able to return to and reside in the residence. Is that right, Ms. Rogers? All right. And we'll modify his bond conditions to allow nonviolent contact and to allow him to reside in the residence again. Mr. Maddox, I would suggest sending me an order on that.
Will do, Your Honor.
Just because I know clerk's minutes often go to the jail and they can figure those things out, but as far as if there's a further issue and people don't see the clerk's minutes as opposed to an order, he could potentially be arrested again because he's having contact, even though I said he can at this point. So let's just get a written order to that effect.
I'll certainly provide the court a written order, Your Honor.
All right. And just send it to me priority through my office.
Will do. Hopefully, I'll be able to do that tomorrow. That would be the latest you get, assuming we're able to open the file in a timely fashion.
What I would suggest, sir, is if, once you get a copy of the order with my signature on it that says that, keep it on your person for the next, little bit.
All right.
Yes,
so
sir.
that, in case it becomes an issue. I don't give the whole story, but it happened to a client of mine one time, probably 10 years ago, and he was arrested for something that had already been the court had allowed him to do. So one time is too many. So just keep
Yes,
that
Your
on your
Honor.
person.
Absolutely. All right. You should be fine.
Oh, PTI will be October 9th at 9. I think I said that before I took her
I
testimony,
believe
but
so,
maybe
Your
I
Honor.
didn't. October 9th at 9 o'clock, just for status. Well, actually, that's going to be to enter a plea.
Yes, Your Honor. Pretrial intervention
It'll be as a
agreement.
plea to PTI, so. All right, we'll see you back in 2 weeks.
4.2.
412.
402.
Of course. Can't save him all.
But you should be fine.
I didn't issue a capias on him, I don't think. Oh, 100%. I just, let's address the case. Now that, he knows to be here. All right, let's bring out Fuentes. Let's go with Fuentes if he's available. All right. All right, so this is going to be Pedro Fuentes. Okay. I believe his case number is going to be 25 CF 1729. I think we already set him for October 29th at 9, but you wanted to bring him over, Mr. Maddox?
Yes, Your Honor.
All
Yes,
right.
Your Honor.
So, Mr. Fuentes, you're going to come back for your pretrial conference on October 29th at 9 o'clock. Information was filed, correct?
Correct, Your Honor.
Yes, Your Honor. I have a copy as
You
well.
have a copy. All right. Anything else from Mr. Fuentes?
Do you have an offer today by chance?
I have not had a chance to review it, no.
Your Honor, Mr. Fuentes has indicated that he'd like to resolve this as soon as possible. Could we put him on 10-9 for possible plea?
I mean, are we gonna, do we have a lot of motions this afternoon, Your Honor? I don't know how long.
To me, it's not the number of motions, it's the length of each one that
Yes,
matters.
well, that's what, I don't know, I can, because I'm working on Mr. McDonald's right now to see for an offer. I can check into this one if we want to push him to the end of the hearings. I can't promise anything, but I can try.
Okay. I mean, Mr. Fuentes has essentially indicated he'll take any reasonable offer that the state makes, so if you can come up with something, then that's fine. If not, we'll talk about it.
All right.
They'll pass him, I guess, Your Honor.
Let's hold them over here so they can see if they get an offer for him.
Thank you.
I appreciate that, Your Honor.
All right, and then Mr. Sheerbaum. Figure out his case. I think I already said him, right? All right, so Mr. Sheerbaum, did they tell you when to come to court?
Yes, sir. I came all the way from Orlando. I had to take my mom back.
Oh, that's fine. I just wanted to make sure because we've had some clerical issues on some cases today.
125 is what they told me.
125? Okay, it was 1:30, but
Okay,
it was after 2:30 when you got here, I think. So,
Apologize so much.
all right, and I don't think we issued a KPS for him.
No,
did
Your
we?
Honor, you did not.
Thank you.
All right, so it's going to be October 27th at 1 o'clock.
Mm-hmm.
Yeah, don't converge. I'm just saying I'll sit behind.
Mm-hmm. No problem.
You have a good day now.
All right, thank you, sir. Are you ready for that now?
Yes, Your Honor.
Okay.
All right, I just need to get his signature. Oh, I already did get his signature.
Yeah, we did, yeah.
Yep, that's right.
Sure did.
All right, I've got it. Your Honor, we reached an agreement in this matter. This is 22 CF 2054, 22 CF 2749.
All right, come on up. These are VOPs?
Yes, Your Honor.
Okay. Oh, it's the reinstate, do we have guidelines?
Your Honor, Ms. Basso will be providing those tomorrow, I believe she said. She is sitting with,
Ms. Barrickman on the
Miss-
trial in the South End?
yes, Your Honor.
Is it going to be a downward departure, though?
Yes, Your Honor.
I'd assume
It-
so, just because I think they always are on these types of situations.
That's correct, Your Honor. He does have a five-year suspended sentence that is still out there and is aware that if he were to violate again, that the state would be seeking the 5 years.
When is that from, the suspended sentence?
I'm going to say last year, Your Honor. May have been even earlier.
Failed to register originally.
All right, so on your original,
Failure to register.
so did you plead out in 2022 or 2023?
23, it looks like.
23, so it'd be from 2023, Your Honor.
I'm just not finding the suspended sentence on anything. There was a plea and sentencing agreement February of 23, February 27th, 23. Oh, there it is, 5 years DOC suspended. So this is his second VOP since he got a suspended sentence?
I'm sorry, Your Honor.
Right. This is his second violation of probation while he's had a suspended sentence. I just. Is this the third?
Yeah, actually, Your Honor, it is the third.
So why are we talking about suspended sentences if someone is allegedly,
There was.
well, has violated, we know, for twice, and this is the allegedly third violation of
There was
probation?
extenuating circumstances on the first two, Your Honor.
What about this one? He was out past his curfew, was involved in a traffic crash. I guess I don't understand. So he's just being put on the same conditions he's already accused of violating?
End of the year.
Just adding some more time onto it?
Yes, Your Honor.
I guess my concern is I don't even have guidelines to look at. All right, who's handling this case for the state, please?
It's Miss Boston.
Ms. Bosso's case, but you're handling it?
Yes.
This is his third violation of probation with a suspended sentence, where all that's being done is he's being back on community control for another 18 months, which is basically the same thing that happened last time. It just extended it 6 more months. Now it's another 18 months. I'm getting to the point, I'm not sure why we're doing this.
I realize, Your Honor, the court concerns, but I don't know all the facts underlying the violations. I can say that the offer that I was originally made was for 1129 jail. We reinstate all the original condition to include GPS and 5 years suspended sentence.
He's had a suspended sentence for 2 years, and would be his third violation of that probation while have a 5-year suspended sentence. I understand that these are relatively small violations and that they're technically prison on every single one of these times that he's been to court. I don't even have guidelines to look at.
Would the court prefer that we move it to the 9th?
Move it to the 9th. I'm not going to consider it if I see some guidelines and y'all want to make some argument to me about it. But, I'm not one to typically get involved in negotiated pleas. But I don't like the idea that he's been on a suspended sentence for 2 years, and every time it just gets kicked, down the street.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic
Mr. Webb, raise your right hand.
downtown Crestview at
Do you swear or affirm the
107
testimony you're about to
North
give
Main
us the
Street.
truth, the whole truth, and nothing but the truth?
Yes, sir.
Please state your name and date of birth, please.
Brian Brent Webb, born 12/4/1953.
All right, Mr. Webb, you're here on 2 different violations of probation, 22 CF 2054, 22 CF 2749. I've been handed a plea and sentencing agreement where the state has agreed that they would reinstate probation for 18 months, electronic monitor at $1 per day, reinstate all previous terms and conditions, waive cost of supervision, $100 court costs, $100 cost of prosecution, $50 public defender fee.
I may have written it down wrong. It's community control.
You're right. It says reinstate community control. Thank you. So that's 18 more months from today. I guess the other issue is, are we going to start getting up to a point where he's already served more probation or supervision than is allowed on third-degree felonies? All right. Is that what you'd want to do today, Mr. Webb?
Yes, sir.
All right. Based on what I was told about this negotiation and readiness for today's hearing, I'm going to accept the plea and sentencing agreement. And I'll talk about that a little more, I guess, once we're done. All right. Did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Completely.
Are you satisfied with your lawyer's advice?
Absolutely.
Okay. Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
You suffering from any mental health issues?
No, sir.
Anyone force, pressure, or threaten you to enter this plea?
No, sir.
Anyone promise you anything in return for the plea?
No, sir.
You understand by entering the plea that there won't be an evidentiary hearing that was set for today?
Yes, sir.
And the state won't have to prove it because you're admitting to your violation?
Yes, sir.
You understand you're waiving any potential defenses that you may have had?
Yes, sir.
All right, and what is your plea to the violations of probation? Are you admitting or denying?
Admitting.
Does the state know what the guidelines came out to?
I can check it on.
Just to make sure, Mr. Webb, you understand that the only reason that you're not getting a prison sentence is because the state agreed to give you this deal.
Yes, sir.
So it's a downward departure based on an uncoerced plea bargain between you and the state. You understand that?
Yes, sir.
So, Your Honor, the score sheet that I have, those are with only one technical points for violation, the 6, so I would have to add the 12 points, but with 6, it was 49 months.
understand that, Mr. Webb?
Yes, I do.
That had it not been for this uncoerced plea bargain that you've made with the state, that you'd be looking at 48 months in prison minimum?
Yes, sir.
All right, and you've got a 5-year, which would be 60 months, suspended sentence.
Yes, sir.
I'll accept your admission as freely, voluntarily, knowingly given, adjudicate you guilty, reinstate your community control. There'll be a period of 18 months starting today. Electronic GPS monitor at $1 per day, reinstate all previous terms and conditions, waive cost of supervision, $100 court costs, $100 cost of prosecution, $50 PD application fee. I need you to talk to probation before you leave here today. I don't think I need fingerprints because he's already been previously convicted and adjudicated, and you have 30 days to appeal the judgment and sentence. Mr. Webb, I do not want to see you back in this case.
Absolutely not, sir.
I'm not sure what's funny. This is
No,
the third
no,
time.
no, sir. No light, man. No light, man. I just appreciate the offer.
Yes, the court costs were per case, and they're run concurrently. All right, Mr. Cotton,
Good afternoon, Your Honor.
is it?
I anticipate this to be short, Judge, given facts and circumstances. How are you?
I think you've been here in the past
Rhetorical
hour and a half.
question, I guess, at this point. Okay, Judge, I think the first case that'll be the easiest to take right now is it's a motion for return of property. Ms. Basso advised me she's in trial today, but she's updated Miss Leone on the status. I think we've stipulated there's only 3 electronic items left in evidence. One is a cell phone, a Samsung Galaxy cell phone. It's outlined in my motion. There are 2 that we have stipulated do not get returned at this time that are still of evidentiary value potentially in the pending criminal case that are iPhones. I think the state at this point does not object and would stipulate to the return of the Samsung Galaxy phone, and I can prepare an order on that, Judge.
That's correct, Your Honor. There's no objection to that.
Just that phone. Haven't we already done one of these before?
The motion's been filed for a while. There was a partial stipulation regarding a computer. Some of the items had previously been returned to the children and/or the wife previously. So it's kind of been piecemeal returned. These 2, I believe, remain pending.
All right, well, just
I'll
send a proposed order that the state's been able to take a look at to make sure they agree to the terms of it.
Certainly.
And send it over to me.
Certainly. Your Honor, the next case, we're here on a case management order on Damon Becknell, State of Florida v. Becknell. That's case number 20CF10. Your Honor, as you can tell by the case number, this is an old case. To no fault of the court, it has just gone past.
I've only had it for a couple of months, so.
We're moving right along here. Judge, this was really, we set this as a short case management conference so we could update the court as to the status of the case. As this court knows, I think it, throughout the process, has finally ended on the last judge in the circuit, or at least in our county, to hear this case. So obviously we have had a lot of discovery in this case. We have had a lot of motions in this case. With regard to the current status of the case, there were motions for reconsideration of a motion to suppress, a motion to suppress a video, and a motion to sever that were pending, and we went to a hearing to have those heard. However, the day before, there was newly provided evidence from the state attorney's office in the form of some new evidence that was provided from a Google search warrant prior to my client's arrest that was 4.5 years old. And we had never received that, and at that time, Judge...
4.5 years before the arrest?
I'm sorry, 4.5 years old is how old the case was at the time prior to it being produced.
All right. I thought you said prior to his arrest. Maybe
No, sir. No, sir. I'm sorry. So that brought up an issue of a Richardson issue, which the court entered an order saying, hey, we're going to hold on the Richardson hearing and allow me to subpoena Google to say, well, what information do you or don't you have? Google very politely told me they don't really care about my subpoena or the courts. I got a court-ordered subpoena in this case. It was not unilaterally issued. And I then, working with the alleged victim's lawyer, she personally has requested the information without response.
Which lawyer is that? Is that Ms. Deviney?
Ms. Deviney, yes, sir. And she has been waiting on a response for that for almost 3 months and has received no response to her own request for her own information. I have provided information to Ms. Bosso, which I think we might have discussed at our last court date, wherein I provided a copy of the subpoena just so she had it, and she was going to work through, I believe, law enforcement or someone in her office to see if maybe they would respond to a law enforcement offer, search warrant and or subpoena, whatever they may have, to see what information.
Search warrant to see what they had 4.5 or 5 years ago.
Well, obviously, I've got a spoliation issue based on some failures of being able to discover that are under the Richardson. We're trying to see what is or is not available to be able to see how to move forward on that issue. What I think Ms. Bosso and I provided that to her about 2 weeks ago, maybe just a hair day or two more or less. Ms. Bosso discussed having her office and or law enforcement attempt to try to get Google to respond to exactly what we requested in the subpoena that the court authorized. And I don't know if she has had an opportunity to get that out yet, and or certainly she told me she has not had a response, so I think she needed some time. I recommended, based on normal time to respond to a subpoena, ducis tecum, 30 to 45 days to put this back before the court. At that time, it would either, we could continue the Richardson issue to be heard at that time. Unfortunately, I don't believe the other motions that are pending and any future motions that would be filed can be moved forward without the Richardson issue being resolved. Is Ms. Leone, I know that was a very verbose explanation of a case you're not involved in, but is that essentially what Ms. Bosso has relayed to you?
Yes, it is. No, it is, Your Honor, yes.
Okay. So with regard to that, Judge, I think at this time, what I would request is this to be reset for Ms. Bosso to have an opportunity to explore her avenues of trying to discover evidence from Google, since we have been unsuccessful in getting a response.
What is the nature of what you think Google has? Just
So the specific, to give you a very, very short background, Judge, the specific.
I'm somewhat familiar despite the fact that I've only been on the case for a few months.
And I know this was going to be a try to educate the court, but 4.5 years is a lot to educate with the docket you have today, and I know you'll give us all the time we need, and I'm happy to give you as much information as you would like. The short version.
I'm just asking, is it documents, videos?
Videos.
Videos. Okay.
Videos. So the specific issue is that when the search warrant was originally issued, they requested, and I'm not going to get into issues with the search warrant at this time, that's a motion for a different date if necessary, but the reality is there is a search warrant that was issued that asked for about, I can't remember if it was 3 or 5 days of video from an automatic camera that automatically recorded audio and video that was placed in the child's room by the child. That when videos were produced throughout the whole discovery process, I think we were given 4. And when I went to my motion hearing to suppress evidence for a plethora of reasons, the day before, Ms. Bosso advised that she contacted the law enforcement officer and said, hey, why haven't you gotten the information from the warrant? Where's the rest of are there any other videos? Why didn't you get a business records affidavit from them? And lo and behold, a business records affidavit apparently was received but never provided. And there were additional videos, but those videos essentially, if I remember, amounted to 12 total videos over a 3 to 5 day period, and clearly have no information other than those that contain my client, which shows that, I mean, no going to sleep, no waking up, no dogs moving, no going to the bathroom, no leaving in the morning. So we want to know where the rest of the videos are and what was removed, tampered, spliced, etc. So that was a long answer to answer the question of what we're missing is information that and evidence of whether or not that was removed by the alleged victim in the case or someone else at her bequest, behest, or with access. Obviously impairing, our ability, that would provide exculpatory evidence, potentially. So with regard to that specific, additionally, obviously, the court knows, as by a quick review of the file, I've got at least 3 motions pending: a motion to sever, a motion to suppress, a motion to rehear, a motion to suppress based on additional evidence provided from the alleged victim in the case.
The motion to suppress and the motion for reconsideration of a motion to suppress that were filed on July 30th of '24, those are 2 different motions to suppress.
They are. And depending upon the outcome of certain rulings, there may be additional motions that need to be filed, but I think it would be premature to file them without answers to the remainder. I will say, Ms. Basso and I did have a brief discussion about attempts to resolve this case. We have not made progress on that. That was very recent, but we are making an effort to try to discuss a resolution.
So what do we need to set next?
I believe that the next thing that needs to be set is a 30 to 45-day date for the Richardson hearing to be completed, for a date for that hearing to take place. That will give Ms. Basso and the state time to explore the ability to recover any information from Google. That, and in my opinion, is probably relevant to the Richardson issue. The other motions can be set after that date because the court's ruling at the Richardson hearing may resolve the case or may affect other motions which may need to be heard, and/or amendment to those motions based on the court's ruling.
$30 to 45 days.
And I picked those dates, Judge, just based on time for response from a non-party to a case to a third-party subpoena or warrant. So I think that would be reasonable. Ms. Leone, do you believe that?
I had 30 days. Can be November 6th, October 30th. That's 35 days. And I'm on, I guess, Mr. Cotter, if you guys don't get the information by the time the hearing comes, then I guess you can ask for a continuance.
Well, I think it would be, that may answer a different question, but I would think the state would, it would be incumbent upon them to make any potential motions at that time if they do not receive their.
I'm looking right now. So what I don't want to do is, because it sounds like this is going to be a lengthy hearing, correct?
I would anticipate that the Richardson issue would be approximately an hour-ish in length.
I could put it on the 30th of October, or I could put it on the 6th in the afternoon, because I currently don't have any contested hearings set that afternoon.
Judge, let me pull up my calendar, please, if you don't mind.
As you can see, we haven't had any contested hearings yet this afternoon, and it's 3:21.
Yes, sir.
Now, hopefully, by the time we get to October 30th or November 6th, we have dockets that have proper case numbers on them. And that won't cause the problems that we've dealt with most of this afternoon. However, I don't want to set a bunch of other things on the same docket as this one if it's going to take an hour or more. But I also don't want to not put things there. This gets continued because we're waiting on whatever it is y'all are waiting on at this point. And then I've got a docket that gets kind of wasted. So I guess I'd rather do it on the later date, just to make sure that there's a better chance that you've received everything or found out you're not going to receive anything else, so that we can have a hearing to finally make some progress in this case. Because,
yes, sir.
Again, I'm not blaming anybody. It sounds like everyone agrees. It's the attempts to get the information that should have been provided or not deleted or whatever it is.
Yes, sir.
5 years ago, so we can actually make some progress in this case. But if y'all want to do a notice of hearing for
which date would you like? What was it, Judge?
The 6th of November. I would just say set it at 3 o'clock, so we're not
3 o'clock.
You're not bumping up against an arraignment date that might go awry like it did today.
All right, Judge. I'll do 3 o'clock, November 6th. For 1 hour. Is that appropriate for the court?
Yeah,
or 1 hour and a half?
If y'all think it can be done in an hour, the other thing I would mention is for you and I guess Ms. Basso to provide me with anything as far as case law or, the motion, the response to the motion, so I can read everything involved, so we can really use that hour to get everything done.
Will do.
Having read everything that y'all are gonna argue.
And Judge, I know earlier is better, but do you have a deadline for when you would prefer to not receive anything after?
I
for
would
ability
like
to review?
everything a week in advance if possible.
And for the court, just so the court's aware, this was not a filed Richardson motion or violation. The court made a determination, and it was a hearing that was held. It began by the court's recognition of the situation in before the last court. They said, hey, we got a Richardson issue, hold. And that's how we got here, just so the court's aware.
So is a motion going to be filed?
I can file a motion, or if the court would like for me to file a separate motion for a Richardson violation, I can. It was just that the court obviously had the opportunity and the ability and obligation at that point to make their own.
Okay, and just to be clear, for the record, when you're saying the court,
The last judge.
A different judge.
Yes, sir, Judge Stone in that case. That's right, Judge.
I think we all know that. We just want to make sure the record's clear.
Yes, sir.
Just because I wasn't involved, I'm not sure exactly how that went down.
Would the court prefer I file a motion in this case?
I think it would help, just as much as I think it would help if the state filed a response to that motion or some sort of memorandum explaining their position. That way, you guys aren't spending the entire hour trying to catch me up to speed on what's happened in 5 years.
Yes, sir. And have everything filed in before you a week in advance, at least, is the court's preference.
I would prefer, because not only do I need the time to read it, especially if it's lengthy, I believe that week before, I'm the duty judge as well, so I'll be pretty busy. I think, in fact, that week before is my next pretrial docket, which takes up basically
Yes, sir.
2 full days. We have a miscellaneous date on the 30th, and I'm on duty that entire week, including the weekend. So I'll
November.
read it over the weekend while I'm sitting on duty.
Pleasure reading for the weekend. November 6th at 3 o'clock p.m.
3 o'clock. If you could do a notice of.
I will
hearing
do
as
so,
well.
Judge. Ms. Leone, is that all you have is with regard to what we needed to address on behalf of Ms. Basso?
Yes.
Okay, and I think that's all I have before the court.
Well, why don't we put this on a pretrial conference date for y'all too?
Okay.
I'm not sure it's worth putting on the October one, because that's the week before this, unless you think it would be helpful to have that just to make sure everything's ready to go, or when you tell me we're still waiting on things and we want to move the November 6th date. I hope that doesn't happen, but I also want to be realistic based on what I've heard up to
So
this point.
is the court saying you would like to put on a pretrial conference docket before the November 6th date?
Yeah,
Okay.
it would be October 27th.
Okay.
That'd be fine.
At
for
9
the
o'clock for purposes of pretrial. I guess just to kind of give us an idea of what's happening the following week.
Yes, sir.
And probably me reminding everyone to have
I
everything
understand.
filed within the next couple of
Okay.
days.
Madam Clerk,
after
will you handle that notice, or do I need to do a notice on that?
Pretrial?
The pretrial conference notice, is that
It'll be in
handled?
the clerk minutes. It's.
We're good on
set
that.
up
I don't
right
need to
now.
file a separate notice on that. Good. Just a notice on the hearing date.
Yes.
Is there anything the court would like for me to address while I'm here? Hope you have a great day.
850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You've been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Cyclone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Procedural Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You've been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You've been injured in an accident and need...
Mr. Fuentes. Your Honor, just one thing for clarification. We did fix on the information. Since it's an attempted burglary, it drops from a level 4 offense to a level 3 offense. That is now reflected properly in the information and properly in the score sheet. It does remain a third-degree felony, though, based on my looking at the statutes. And then we've reached a resolution, if I may approach, Your Honor. Score sheet and the updated information are attached.
It is a guideline sentence, Your Honor. Yes.
By a point. are you filing this, Mr. Sheik, as an amended information, or?
I don't know, does the court need me? It's the same information. It was just, when I filed it, it was F3, L4. And the actual, because it was attempted, I forgot to lower it to an
Actually,
F3,
should be an
L3.
L3.
Yes, Your Honor.
All right. Can you raise your right hand, sir? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
And can you state your full name and date of birth, please?
Pedro Andre Fuentes, December 23rd, 1983.
And Mr. Fuentes, you're here in 25 CF 1729, where you're charged with attempted burglary of an unoccupied conveyance, third-degree felony. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement between you and the state that calls for you to plead no contest to that attempted burglary charge. In return, you'd be adjudicated guilty, so it's a felony conviction. You can put your hand down. Felony conviction, 3 years probation, complete a substance abuse evaluation and any recommended treatment, $150 cost of defense, $615 court costs, waive cost of supervision, no contact with the victim, reserve on restitution for a period of 90 days. Is that what you want to do today?
Yes, sir.
Is that the state's offer?
It is, Your Honor.
All right, Mr. Fuentes, have you gone over this plea and sentencing agreement with your lawyer, Mr. Maddox?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
I am, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
And are you currently suffering from any mental health issues?
No, sir.
Do you I'm sorry. Has anyone forced, pressured, or threatened you in any way to enter
No,
this plea? Anyone promised you anything in return for the plea?
No, sir.
Do you understand by entering a plea of no contest, there won't be a trial of any kind?
Yes, sir.
Do you understand you're giving up your trial rights, which are listed on page 2 of the agreement that you signed?
Yes, sir.
Do you understand you'd be waiving any potential defenses that you may have?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
And what is your plea to the attempted burglary of an unoccupied conveyance?
No content.
All right, I'm going to accept your no contest plea as freely, voluntarily, knowingly given. I'm going to adjudicate you guilty. 3 years probation, complete substance abuse evaluation, any recommended treatment, 150 costs of defense, 615 court costs, waive costs of supervision due to the fact you're represented by the public defender and have been declared indigent. Order that you have no contact with the victim, and I'm going to reserve on the issue of restitution for a period of 90 days. I need you to meet with probation, and then you need to be fingerprinted, and you'll have 30 days to appeal the judgment and sentence of this court. I have reviewed the sentencing guidelines. He scores 43 points. You understand, Mr. Fuentes, that's 1 point under where you'd have you'd score prison.
Yes, sir.
And if you violate, even for a technical reason, that would be 6 points. You would score prison if you violate your probation or have been found to violate your probation.
Yes, sir.
All right, so it's very important you get everything done properly.
I will.
All right, anything else?
Just to say, I also went over that with him, Your Honor, in anticipation of him entering his plea, and I also went over the fact that I, had not gone over any of his discovery or anything, and that he may have possible defenses here.
Okay, you understand, but you're waiving those defenses because your lawyer hasn't even had a chance to look through them because you're entering a plea at your arraignment date.
Mm-hmm.
Yes?
Yes, sir.
Okay. All right.
All right, thank you, Your Honor.
Thank you, Your Honor.
Good luck.
Thank you.
You're welcome.
I think it already was attempted. He just had it at the wrong level. But it's at the bottom of that stack.
Yes, I had it right on my computer. I just forgot to delete and re-add.
What was that other one you wanted to talk to me about before? Say again. Mr. Maddox, before you walk out,
Yes, Your
Honor. Does anyone have anything on a Thomas Christopher Reeves?
Let me check my docket, but I don't believe so, Your Honor.
So I just
130
looked.
docket, Your Honor.
Is this the right case number?
Said Christopher Reeves.
No, Thomas Christopher Reeves.
Thomas Christopher Reeves.
'Cause I looked it up by the case number, which is 25 CF 1741, which lists his name, but the paperwork in there with that same case number, which at least everything that was filed by your office, Mr. Maddox, says Braden Gary, who was on the docket earlier.
Case number for it, Your Honor?
Well, that's the question, isn't it?
Oh, okay.
He's also in jail.
I think I have 1741 as well, Your Honor, in our system. Obviously.
I'm just wondering if PD's system has 1741 as somebody else.
Thomas Christopher Reeves, last name Reeves?
Yes.
Okay.
I'm showing that he's in jail. This is a battery on detained. Looks like he probably has other charges in Fort Walton.
I do not, Your Honor. I will certainly look at it, though, when I get back, and if I see anything, I will email your JA, Your Honor.
I just want to make sure he has a proper court date and that we didn't miss it today. 'Cause he was set for arraignment today at 1:30. But he's not on any docket that I've seen.
We're here to do, though.
For some reason, the clerk had a minute sheet.
Yeah, I believe we just got it today because I'm seeing it just inputted into our system, Your Honor. Most likely, we will be sending this to the South to join its companion case.
I'm showing 25 CF 1570 is still pending in front of Judge Stone. 1582 in front of Stone, then I have 1741 that's listed as him, but it says battery by detained, and then there's 1746 battery by detained person.
We'll get it figured out, Your Honor.
I also want to take a look at it. I mean,
You want to set it for 10-9? Control date maybe for 10-9, Your Honor?
let's put it for 10-9 for control date. If also, Mr. Sheik, if you could look at to see if y'all are going to transfer it to Judge Stone's division anyway, because that's where his other pending cases are. I don't even know if it's supposed to be one case or two cases. It's just, I think I've lost about most of my patience for this stuff today. It's just,
I understand
there's
that.
been, I mean, we can't even figure out what cases we're supposed to have and how many of them. It's just the system's become unmanageable.
Yes, Your Honor, and then obviously I'll relay to Mr. Russell.
Mr. Thomas, I don't need you to make faces over his shoulder at me. I understand you're here.
I'll obviously relay the intention of having a meeting with the clerk to Mr. Russell.
All right, thank you.
All right, tricky.
Just, I'm trying to talk to him and you're,
I was just looking, sir, paying attention, that's all. I'm sorry.
yes, sir. 10-9, 9 o'clock. Or no, 10-9, 1:30. All right, we ready for Mr. Thomas's case?
Yes, sir, Judge.
Yes, Your Honor, the city is ready.
Judge, before we start the hearing, there are some things I need to put on the record because it'll affect how we proceed in the future. In this case, State of Florida versus Cordell Thomas, case number 2024 CF 906, the State Attorney's Office has offered Mr. Thomas a plea negotiation of 60 months in the Department of Corrections with credit for all time served, and that would have a 3-year minimum mandatory because of the methamphetamine that was found. I believe if we proceeded, the original offer was 10 years with a 7-year minimum mandatory, but he's going to score a lot if he went to trial and was convicted. Okay. The deal was if he proceeds with this motion to suppress a day, the state is going to remove that offer from the table and we'll be proceeding with no offers from here on out. Or maybe something worse, maybe the original offer of 10 years, but the offer of 60 months is going to be withdrawn today. And I wanted to make sure that was placed on the record and the court can conduct whatever colloquy it needs to make sure
Sure.
Mr. Thomas understands that.
All right, Mr. Thomas, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, do you understand that the plea offer that's been given of 5 years with a 3-year minimum mandatory is going to be withdrawn as you go forward with this motion to suppress?
Yes, sir.
And you understand the state doesn't have to give you any other plea offer?
Yes, sir.
And that it may be that you ultimately either have to plea up straight up to the court or go to trial, and if you're convicted, then I would sentence you according to the guidelines and the arguments of the parties. That doesn't mean I would give you a guideline sentence. I don't know until I hear everything if you were to be convicted. The way I said that, I just want to make sure you understood that, I'm not required to give you the guidelines exactly. It can be more than that. It can be less if you argue a downward departure and convince me to do so. All right. Any questions about that? Has your lawyer discussed that with you?
Somewhat, yes, sir.
I mean, do you need more time to speak with him? I mean, he just went back and spoke with you right before the hearing, right?
And he walked out, too.
Yeah, I did. I'm going to bring something else up as well.
Okay, go ahead, Mr. Cobb.
In preparation for the motion to suppress, I've met with Mr. Thomas at the jail yesterday. I talked to him there. He wants to proceed with a line of argument and a line of questioning about something that's not even on the table today. He wants to litigate the possession portion of the case, about whether or not he possessed the methamphetamine. I told him we're not here about that today. I've instructed him that he cannot say a single thing about that today because he has a right to remain silent. And I asked him in the back there if he's going to follow my instructions and not talk about that today. And he said, no, I'm not. I'm going to talk about it. If you don't talk about it, I'm going to talk about it. He told me he wasn't going to follow my instructions, and I want this to be placed on the record. I'm doing everything I can to keep from having to file a motion to withdraw from Mr. Thomas's case because he's already gone through 2 other attorneys, and I don't want to prolong this any more than it already has been. But if he's unable to follow my instructions, I don't know what to do. So I'm going to ask Mr. Thomas, will you follow my instructions and not talk about any of the possession stuff here today?
Your Honor, if I may speak, all I was asking him was to put, I got everything that I won't put on the line. I want to put all this on record. That's all I was asking him. He's been on my case for 120 days. I've just seen him twice. My family members called, blowed his phone up, trying to get him to come see me. Only seen him twice. The other lawyers that I had, only seen them probably 1 or 2 times. It's not my fault that I haven't seen my attorneys. I can try to contact them several times.
I understand. Your last lawyer, Mr. Kleins, was only on your case for a very short time.
Yeah, he came
Can I finish?
Yes,
Was
sir.
only on for a very short time before you wanted him off your case due to the fact that you had concerns about the predecessor in his office who was representing you, right? Right?
Yes, sir.
Okay, so, I mean, he was not very long. As far as, what's the other case?
Your Honor, if I may.
Just a second. Looks like Mr. Cobb was appointed to you on I've got June 3rd, but so.
There was a delay in me getting the order. I've been down to the jail and I talked to Mr. Thomas and I explained to him everything that happened with regards to issues with my family in the beginning of July and the whole month of July. I have been down to the jail. I discussed his case thoroughly with him. He's explained to me everything there is to know about the case. I've reviewed all the discovery, all the videos. If he's saying that I'm ineffective right now because I haven't come to see him, he needs to put that in a motion or something or make. Is that what you're saying, Mr. Thomas? I'm ineffective?
Sir, no, sir, I'm not saying that you're ineffective. I'm saying that you haven't came and seen me like a regular lawyer.
Well, I don't babysit defendants.
Hold on.
I go down and see them, I talk to them, I go over everything, and then if there is an additional need for me to go to the jail, I will. And that's what I tell all my clients.
I understand that, and I don't want to start off on like we're starting off on a bad foot. What I'm saying is that I done had probably 3 different attorneys since this. And then I told you that I wanted to go over all the case laws that I looked up, all the probable cause. The officer don't have proof of probable cause. Even the traffic ticket is showing that he stopped me for speeding. You said it wasn't on the motion, so you might not even be able to argue that. Well, if you didn't like the motion, why did you adopt the motion? If you wasn't.
All right, if y'all need to have a conversation, I can send you back into the interview room.
He walked out on me, Your Honor, and I'm just trying to make sure this is my life on the line. This is my livelihood on the line. I don't, like, just come in the next day and then say, okay, we're going to go to the suppression hearing. You're not going to win like this. Well, don't say nothing about the possession, even though they can't convict you.
Just to make sure you understand what we're here for, Mr. Thomas.
Yes, sir.
It's a motion to suppress evidence.
Yes, sir.
So it's only about whether or not there was a proper traffic stop and search of the vehicle. What they found in there and whether or not they can prove that you possessed it is a trial issue. This is not the trial. What I'm gathering from what Mr. Cobb has said is, don't talk about the possession issues because then you've said it in a room with the prosecutor and everything's recorded here and can be used against you. So you don't have to testify about these things. And whether or not they can prove that you knowingly possess something is not for today's hearing.
Well understood, Your Honor. Well understood.
Okay. Anything else?
Yes, I just wanted to make sure that we went over, like, I have case laws over here that I wanted him to present to the court as well, and if I needed to be put on the stand, I would like to be.
Well, you don't get put on the stand to argue case law.
Judge, if I may, the case law that he is citing to, it's all within his motion to suppress. I've read the motion to suppress. I've read all the cases. I have a complete grasp and understanding of what they mean and how they're applied. And I've tried to explain that to him, and he doesn't like my explanation or my analysis of the cases. My analysis doesn't meet with his expectations or what he thinks it should say. And I've tried to explain to him about that, but he refuses to listen to me about that. That's where we're having that's where we're not having a meeting of the minds. He doesn't respect or even consider the fact that I've been doing this for almost 30 years. I've had dozens and dozens of motion to suppress hearings involving traffic stops, and I'm trying to explain to him how this all is supposed to proceed, and he just won't listen to me. And so I'm not going to file a motion to withdraw. I'm going to do the best I can today at this motion to suppress hearing to fulfill his expectations and then move forward. But I told him he doesn't need to testify. I've never had a defendant testify in a motion to suppress hearing ever. Not that I can recall. And unless I thought it was absolutely necessary, I still am going to maintain that. I'm never going to let a defendant get on the stand and testify. I think we can get what we need to get done today with the officer, watching the video, and then legal arguments based on the motion.
Okay. Anything else, Mr.
Let's
Thomas?
proceed.
All right. Stay prepared to go forward.
Yes, Your Honor.
How many witnesses do you have?
One.
Just the one.
Sergeant Savoy.
Are there any other witnesses?
No, not from the state.
Mr. Cobb, on your side?
No, sir.
Okay.
Do you want to talk about video and then play the video, or go through all the way and then play?
We can play the video, Your Honor. That's fine.
What would the court prefer?
I know y'all like to ask me that, but I always say I don't prefer it. You put on your case the way you want to put on your case. Because if I tell you I like this or I don't like that, that may change how you conduct your strategy, and I don't want to be a part of seeming like I'm telling people what to do in their cases.
If we play the video first, then we both can ask questions about the video after everybody's out.
Okay. I mean, asking what I prefer to me is like asking a football referee what play you should run. I'm not going to give you any ideas on that.
Yes, sir.
The court is no longer on.
Just to make sure I heard, are y'all stipulating to playing the video that it's?
Yeah, I was asking him, Your Honor, why.
I need you, do you want to argue your own case or do you want your lawyer to argue it?
I would like him to help me do it. Excuse
No,
me.
he's not going to help you do it. He's either going to represent you as a lawyer and act as your lawyer in questioning witnesses and making argument, but I'm not going to have you jumping into every part of it, Mr. Thomas. If you want to represent yourself, we can discuss that too. And I'm not trying to say you should do one or the other, But it's not a situation where a defendant can just jump in and say, I want to say this too. If you're going to testify, that's one thing, but you don't get to make arguments if you're represented by counsel.
Not allowed to ask them anything while you.
You can talk to your lawyer, but I would do so in a way that no one else can hear you. Because you raised your hand to ask if you could say something else. And I'm just trying to make sure y'all are communicating, but that I'm not hearing everything, the state's not hearing everything, or the microphones aren't recording everything that you're saying, because it could be privileged information. All right. So is there a stipulation as to the admissibility of the video?
Yes, there is. I believe you've already watched it once. We're going to do it to watch it. I don't know if the first time, if you watched the whole 18-minute video, I think that would be in excess, the first 18 minutes, because really what's relevant is the first 5. But
all right, let's just kind of reset it for the record, because I think we talked about it earlier today, but also just to make sure the record's clear. When Mr. Kleins from RCC was representing Mr. Thomas, this same motion was set for hearing. To avoid a lengthier hearing, the parties agreed for me to watch the video in advance, so we didn't have to all sit here and watch it again. So I have seen the video previously. I think that was probably 4 or 5 months ago. So I've seen the video already, because it was already stipulated that it would be admissible. As far as how much y'all want to play, I'll let that be up to the state on how much they want to play. If Mr. Cobb, you think more has to be played than is played, you can certainly pursue that as well.
yes, sir.
But I believe I watched, I want to say it was 20 minutes is what I was told to watch. For some reason, I think 20 minutes and 53 seconds sticks in my mind somehow, but I can't say that's for sure it was this case. But I watched whatever the parties stipulated me to watch, but it was 4 or 5 months ago.
Yes, Your Honor, it was more than 5 minutes, because I guess the argument that they're making is that the Sergeant Savoy didn't have the right to hold him longer than the time for giving him the ticket. And the video shows that the reason instead was the fact that the defendant had lied about his name, and he didn't have a driver's license, and Sergeant Savoy had to verify that information, and that's the time that it took.
Okay.
So.
All right. So do you have a copy of a hard copy of the video that's going to be entered?
Yes, Your Honor, it's in my, yes, right
Okay.
here.
All right.
It states Exhibit 1.
All right. And then there's no objection to that being played? All right.
No, sir.
All right. And then States Exhibit 1, which is a video of the traffic stop, will be admitted without objection.
It's plain for me.
Yep.
That
Is it on or not?
I have to do it still.
Oh, okay.
Shut the door. Take the keys out. Take the keys out. You make it Coleman and West First on a blue Dodge Caravan. Shut the door. Take the keys out. Take the keys out. I said take the keys out for me. I'll explain it all to you. Take the keys out. Hey man, you do me a just put them up on top. Appreciate you. Show me both your hands real quick. Appreciate it.
Oh, come on, man. Them cars in front of me, boss.
You switched over to left-hand lane. You're doing 45, it changes 35 right there.
Okay, but the cars was in front of me.
I can tell you I'm not going to write you a ticket for it.
Okay.
All right. You got your driver's license registration?
Yes, do it.
Well, I get that's your name. Do you have your driver's license?
I don't have it on me.
Okay. Do you have a driver's license?
Yes, sir.
Okay. Where you coming from today?
Just riding, man. Just trying to go get my kid.
I got you. What's your last name?
Dorch.
D-O-R-T-C-H. R-T-C-H. Your first name?
Javis.
J-A-V. Just I-S?
Yeah.
And what was your middle initial?
Raphael Park.
And your date of birth?
6/14/84.
What's a good phone number for you?
850-682-9401.
9401?
Yes, sir.
All right. Give me just a few minutes, all right, man? All right. You got the registration and the insurance on the vehicle?
Yeah, thanks.
Is this your ride or you borrowing it?
My cousin.
You take it out all that for me, please.
Maybe I call her. See what might be in.
Okay. Tell you what, you keep looking for that, I'll go handle things, all right?
All right, thank you.
Yep. Name, date of birth. Last name Delta Oscar Romeo Tango Charlie Hotel. First name Javis Juliet Alpha Victor India Sierra. Middle initial R Romeo. Date of birth 6/14/1984. Black male. I'll be right there. You able to find it?
I got the feed on top of the
Man, what were you eating?
Man, from down there, Brown.
Yeah? So what's your social?
I don't know about heart.
You don't know by heart? All right, what's your best guess?
I didn't even have my idea of paper or something like that. I don't know about that.
Okay.
So it's not popping up?
What's that?
Not popping up?
Yeah, I'm waiting on it to return. That's why I'm making sure. Yeah, my computer's running slow today. Getting all jacked up. I think it's like all the cloud cover and everything. I'm not really sure. Acting all kinds of weird.
That's the right thing, though, Amy. All right, baby, I'm all right. This ain't gonna give me no ticket or nothing.
No.
All right, I get it. I put it in my wallet next time.
You got the insurance card?
Yeah, I don't know, man. You gotta look at that. What insurance card, Amy?
It's in the same thing.
It's in the same thing.
It's in the same thing?
Yeah.
Give you that one back.
Something calls going a little faster than me.
Yeah. I just never seen a minivan move like that, man.
Man.
Here you go. Hang on to that for a minute. Give me just a minute, okay?
Got it.
No, I didn't, but I'll look it up in our thing.
Okay.
We just look for the card and all that, so. You don't know your social security number. Let's see. All right, so what's your address? What's your address?
Where is my address? I don't have a permanent address. Wait, my license, I got license.
Yeah, what's your license address?
Your Honor, as far as I'm concerned, we can stop showing the video here. Mr. Cobb agrees. If the court wants to see some more, I'm fine.
I don't express any sort of desire to see more or not see more. Y'all make that decision.
I'm fine if that's all the court watches and doesn't watch anymore. So do we need to redact the CD so it's just that particular section of the video, or do you want the whole video admitted into
Well, I
evidence?
think if y'all stipulate as to what time I'm no longer watching the video, I think that's sufficient.
We'd stipulate to the mark 13:43:35.
That would be fine.
So as far as what we're talking about, it's the timestamp that's up in the upper corner, upper right corner. It's 13:43:35, which would be 1:43:35 in the afternoon. Also, I'm looking at the actual video on the bottom. It's the video is 1 hour and 39 seconds long. At this point, we're 11 minutes and 11 seconds into that.
Yes, Your Honor.
All right. And it'll be stopped here, correct?
Yes, sir.
And I won't review anymore. All right.
State calls Sergeant Savoy.
Come on up. Raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Take a seat. Make sure you speak into the microphone.
State your name for the record.
Colin Savoy,
Where do you work?
currently with the Okaloosa County Sheriff's Office
How long have you been working for the sheriff's office?
since August of 2018.
What are your duties right now?
I'm currently a patrol supervisor, rank of sergeant. I supervise deputies currently in the District 3, which would be the Destin, Niceville, Bluewater area.
Were you working on April 18, 2024?
I was.
And what were your duties back then?
I was a patrol supervisor assigned to our District 1, which would encompass everything north of Duke Field.
On that day, did you come into contact with a person who later became known to you as Mr. Cordell Thomas?
I did.
Do you see him in the courtroom today?
I do.
Can you point to him and identify him by an article of clothing he's wearing?
He's seated behind you wearing orange.
Let the record reflect the witness has identified the defendant.
Record shall reflect.
Do you remember where you encountered the defendant on April 18, 2024?
He was operating a vehicle that I conducted a traffic stop on.
Do you remember the location?
He was operating on Highway 90 whenever I first observed him.
And is that in Okaloosa County?
Yes.
Tell us about your training and experience.
As it pertains to,
Law enforcement in general, and if you have any specialized training into speeding.
okay. So law enforcement, as I said, I've been employed since 2018 with the Okaloosa County Sheriff's Office. During that time, I've served on the patrol division as a deputy, our street crimes unit, special investigations, special weapons and tactics. My training as it pertains to traffic enforcement, I've attended the Florida speed measurement course, which is a 40-hour course required in order to operate laser and radar speed measurement devices. It also requires that we conduct somewhere in the area of 100 visual estimations, where we have to be within plus or minus 5 miles per hour of the vehicle. So to explain that further, we observe a vehicle, and without using any type of instruments, we have to visually estimate the speed of that vehicle, which is then confirmed by using a speed measurement device utilized by a separate person. In order to pass the course, you have to be within plus or minus 5 miles per hour of that vehicle speed based on visual estimation alone. I've also attended a course to teach and instruct that course, so the laser and radar instructor course, whereas we're required to perform that action and an additional 200 times per laser and radar device. So somewhere in the realm total 80 hours of training, and on paper somewhere in the realm of 500 visual estimations, whereas I'm within plus or minus 5 miles per hour of the vehicle speed.
Thank you. On April 18, 2024, what was the reason for you stopping the defendant?
Speeding.
And how did you determine that he was exceeding exceeding the speed limit?
He was currently in a 35 mile per hour zone. I visually estimated him to be in excess of that, somewhere in the realm of 45 to 50 miles per hour, also due to the fact that he was overtaking other civilian traffic on the roadway. Positioned my vehicle behind him and then paced him with a digital speedometer that's in my patrol vehicle, certified, and the most consistent speed that I observed him to be traveling at would be 45 miles per hour in the 35 zone.
Did you notice anything else about the defendant's either a driving pattern or behavior as he was driving?
He swapped lanes as I began positioning my vehicle behind him. As I said, he was overtaking some vehicles and then swapped over to the left lane to overtake some other vehicles. And that's where I conducted my traffic stop once I got behind him and got a good speed reading on my speedometer.
So did he comply with your commands to pull over as soon as you did?
So when I initiated the stop, he did pull into a side street, and then as you can see in the video, he pulled into a business, so I would say yes.
Well, we obviously watched the interaction on the video. I'm not going to go in details into what he told you. Basically, you asked him for his name?
I asked him for his driver's license, his registration, and proof of insurance for the vehicle he's operating.
And is that a common procedure when you are on traffic stops?
Yes.
What's the reason for you to check about his name and driver's license?
To ensure that he has a valid driver's license issued somewhere within the United States that allows him to operate a motor vehicle.
Were you able to readily determine whether or not he had a driver's license?
No, I wasn't.
You made multiple efforts?
I did.
What kind of database did you check to verify the name that he gave you?
The name that he gave me, I utilize our master name index, which is the sheriff's office, all the people we come into contact with, and also our database. I also utilized our communications, calling it in over the radio, who runs it through several different systems, and FCIC, NCIC, and then furthermore, as I go back to my vehicle, I also use an additional law enforcement database of links, which covers multiple different agencies, police reports, and information.
Did your interaction at this time with the defendant create any kind of suspicion based on your training and experience?
It did. So normally, based on my training experience, when somebody does not have and is not able to readily present their identification, it most of the time will be a result of it being seized during a previous interaction due to suspension. It could also be a means that they don't have their identification because it readily identifies them and would yield that they have a warrant, a suspended license, anything of that nature, whereas if they have rehearsed a name or date of birth or some information, they can readily present that. Also, being unable to present any type of identification on him and then running the information he gave me, the photograph, you can see I look at it multiple times because it just does not resemble him.
And that you never encountered him in the past prior to this stop?
I haven't, not that I can recall.
Did you say that you also check suspects' records for outstanding warrants?
Yes.
And is that within your duty as a law enforcement officer?
Yes.
Did you eventually find out his real name?
I did.
How long into the traffic stop did you find that out, approximately?
I would have to watch the video, see, but it's significantly longer time, enough time for a backup unit to arrive and ask him multiple more times what his information is.
Did you eventually find out what his real name was?
I did.
Did you find out if he had a valid driver's license?
I was able to use that information to see if he had a valid driver's license, which he did not.
No further questions, Your Honor.
Mr. Cobb, Cross?
Boy,
Savoy, sir.
Savoy?
Yes, sir.
Okay. How many tickets do you give routinely for somebody traveling 10 miles over the speed limit?
I wouldn't say frequently.
Okay,
Very little.
Thank you. How many traffic stops do you make typically when somebody's traveling 10 miles over the speed limit?
I would have to look at my numbers.
It's infrequently. Would you agree?
No, sir, I would not.
So you do stop people for traveling 10 miles over the speed limit, but you don't always give them a ticket. Is that what you're saying?
That is correct.
And you said that you paced him when he switched over from a 45-mile-per-hour zone to a 35-mile-per-hour zone, correct?
No, I paced him when he was switching lanes. He had entered into a 35-mile-per-hour zone at that time.
All right. Well, how long had he been in the 35-mile-per-hour zone before you stopped him for going 45?
Enough time for him to be speeding, passing several signs indicating it's a 35-mile-per-hour zone.
So is it your testimony that you waited long enough for him to slow down and resume the 35-mile-per-hour speed limit, or as soon as you got into the 35-mile-per-hour zone, you lit him up?
He was within the 35-mile-per-hour zone. For how long? Enough time to be speeding, sir.
Okay, but would you agree with me that when a car enters into a 35-mile-per-hour zone from a 45-mile-per-hour zone, there's a period of time for the car to slow down?
No, sir, that's the signs that are indicated on the side of the road telling you it's a different zone.
So drivers are just supposed to slam on the brakes and immediately go to 35 miles an hour?
No, sir, they should begin decreasing their speed once they observe the signs.
Okay. And you're saying that the signs were readily posted where he could see and know that it was switching to a 35-mile-per-hour zone?
Yes, sir, it's US Highway 90.
Okay, and you went on about your qualifications to run radar and guesstimate speeds observable. You said numerous times you've been tested about that. But you didn't use radar in this case, correct?
No, I did not.
And you had a visual estimation, and you said you visualized him going, what, 45 miles an hour?
I estimated visually that he'd be traveling in between 45 miles per hour and 50 miles per hour.
Was that estimation when he was traveling in the 45-mile-per-hour zone or when he got into the 35-mile?
He was in the 35-mile-per-hour zone at that time.
See, that's what I'm trying to get at, officer. I'm trying to determine how long you followed him in the 35-mile-per-hour zone before you decided to pull him over for speeding.
And I apologize, I don't have an exact distance.
Okay, isn't it also true that when it comes to pacing him with your digital speedometer, we only have your word to go by, correct?
If it's not caught on camera, and my agency currently doesn't have dash cam, so yes, you would have to go off my word.
If you had used radar, we'd have some form of radar proof that he was speeding, correct?
No, sir. If it was not caught on dash cam and if it was not caught on body cam, you still wouldn't have the evidence.
When did you decide not to write him a ticket for speeding?
I normally enforce warnings, which is also common practice with the sheriff's office to educate as opposed to constantly writing everybody tickets.
You watched the video, we all saw it. Wouldn't you agree that your first response to Mr. Thomas was you weren't going to write him a ticket?
That is correct.
Right. And then after you told him you weren't going to write him a ticket, you asked for his name, or driver's license and name, correct?
That is correct.
How many times do you tell somebody you're not going to write them a ticket and then run through the process of getting their identification and name?
Pretty frequently.
You ever tell somebody you're not going to write them a ticket and just say, hey, slow down next time and let them go?
I would say no.
Every time you stop somebody for speeding, you run their identification and ask for their driver's license and name, correct?
Yes.
Your testimony that you had no idea who Mr. Thomas was prior to the stop?
I did not recognize him, no.
Do you have any suspicion that Mr. Thomas was involved in narcotic possession at the time of the stop?
No, sir.
Do you have any suspicion that he posed a danger or threat to you at the time of the stop?
That I did. Well, threat of flight. As far as wanting to harm me, I won't say that I had that, but I did have some suspicion that he may try and flee from the stop.
Can you articulate why you had suspicion he might flee?
Yes, when conducting a traffic stop, it's also not commonplace for people to try and exit the vehicle. Constantly watching my movements, sitting with his foot on the brake. That is why I instructed him, hey, take the keys out, place them on top of the car, just to prevent any of that because I'm about to approach this vehicle that could then suddenly take off.
Get at is the reason you asked him to take the keys out and put them on the hood of the car.
No, it's because I observed that the third brake light is still active, meaning his foot's sitting on the brake, meaning he could place it back into drive or reverse or whichever in order to take off.
You've asked him to turn the car off.
Yes.
Would you agree that when you ask a driver to place the keys on top of the car, you're in effect seizing that driver at that moment?
I would say once I activate my emergency equipment, he pulls over on the side of the road, that driver is seized at that point.
Then would you agree with me there really wasn't a reason for you to ask him to put his keys on top of the car?
I won't agree with you on that.
So is it your testimony that if Mr. Thomas had given you his correct, he gave you a driver's license, a valid driver's license, a valid name, you'd have just let him go?
After I conducted a query of the information provided to me, yes.
And it all came back and cleared you to send him on his way with a warning?
Yes, sir. As a matter of fact, attached to his arrest paperwork is a warning.
All right. And how long into the traffic stop did you realize or find out that he didn't have a valid driver's license? I think you stated, but...
I don't have the exact date time stamp. It was once I figured out his actual identity.
All right, those are my questions.
Redirect, Ms. Leone.
Just very quickly. Sergeant, you said that when you initially noticed Mr. Thomas driving, it wasn't just the speeding, it was some other pattern of driving that caught your attention.
Yes, so he's passing other vehicles on the roadway, other vehicles that are all traveling at what I visually estimate to be around 30 to 35 miles per hour. He is overtaking them, passing them. He is the only vehicle that it drew my attention to that one vehicle. Normally don't see minivans. I even make the comment to him. Don't really see minivans moving that quickly. He was overtaking other vehicles that were traveling in the same direction of him, meaning it's reinforcing my estimation that he is speeding.
Thank you. No other questions, Your Honor.
Take your seat, sir.
This argument.
Oh, I'm stuck.
Cobb, any witnesses?
No, sir.
Mr. Thomas, I know we talked about this a little bit earlier, and I'm not trying to encourage you or discourage you from any particular action, but do you understand that you have the right to testify if you'd like to?
Yes, sir.
Okay. Do you understand that you also have the right to remain silent and not testify in this hearing?
Yes, sir, I understand that.
All right. Do you need any more time to speak with your lawyer about whether or not you think you should or shouldn't?
Yes, most definitely.
You need more time?
Yes,
Okay. Go ahead and speak to your lawyer.
The officer mentioned a warning citation that he gave. I did not see it in discovery, but I'm going to go find it because Mr. Thomas is demanding to see it.
Okay.
So that's what I'm doing right now is looking for it.
All right. And the only reason I'm putting on the white noise is so I can't hear what y'all are talking
Yes,
about,
sir. I understand.
or anybody else can. That also shuts off your microphones, so that won't be broadcast through the room.
If you leave it on too long, it's what we listen to at night. Sometimes we go to sleep at my house, so.
Let's hope we don't get to that point in the
Yes,
day.
sir. I don't see it, but I'll argue in my argument that I don't see it.
Okay.
So we'll present that.
Mr. Dortch, do you need more time to speak with your lawyer about whether or not you want to testify?
Mr. Thomas, sorry, Judge.
Oh, I'm sorry. Mr. Thomas,
Yes, sir.
you need more time to speak with your lawyer? I just gave you about 5 minutes or so, and you'll say you're ready. Do you need any more time?
I just want to ask, would I be able to get a copy of my discussion?
You have to talk to your lawyer about that. That's not a question I answer.
Yeah, him and I have discussed this about it, and I will continue to discuss it with him. I was under the impression that his 2 prior attorneys had copied everything and sent it to him, and when I went down to the jail, he had a folder of stuff. But if they didn't, he'll get everything I have, all of it. So, but that's a different topic than what we're here about today.
No witnesses then, Mr. Cobb?
No, sir.
No other evidence?
No, sir.
All right, state's argument?
Yes, sir. And I believe, Your Honor, of course, I'll give you the citations again. At the time when this hearing was set previously, I think I sent an email with case law that I was going to reference.
I don't recall that, but I'll take a look.
Well, one is Rodriguez v. State, 575 U.S. 348. Then I have Delaware v. Prowse, 440 U.S. 648.
I'm sorry, could you give that again?
Yes, sir. 440 U.S. 648. Then there is Cabales, is 543 U.S. 408. And also Campbell v. State. That would be, making sure I'll find it here. Campbell v. State is 26 Federal 4th 860. So basically, Your Honor, case law is very, very clear in terms of how long a valid stop can be prolonged. And one of the reasons why it could be prolonged is because the Constitution gives a law enforcement officer the right to check on validity of a driver's license of the person who's pulled over, and also to check for potential outstanding warrants, even after they've finished conducting the reason for the traffic investigation. The case that was mentioned by defense in its motion, it's distinguishable from our case. In that particular case,
Which case? I believe there's a couple of them. Just
W.
White?
Yes, with state.
WHYTE versus state?
Yes, I was trying to pull it up here. I haven't yet, but there were a couple. You're right, Your Honor. It's the one that was mostly, I guess, on point compared to the other ones. Is that case in which law enforcement stopped the defendant for the purpose of a welfare check. And the law enforcement officer in that case was concerned for the condition of the defendant. The defendant said that he was drunk. And law enforcement at that point asked for his name, and the suspect lied about his name. And the reason why law enforcement arrested that particular suspect is because law enforcement was familiar with that particular suspect. He knew the name. So when he asked for the name, he knew that that suspect had lied to him. And that's why he charged him ultimately with giving false ID to a law enforcement officer. So again, first of all, a welfare check and the extent of a welfare check is not the same as a valid traffic stop. Second, in that particular case, the defendant said that, he was impaired. He wasn't driving. He was not driving the car. We're not talking about a DUI in that case. He was a pedestrian. Additionally, had the law enforcement not known what the real name was, he couldn't have charged him with lying to law enforcement officer. Obviously, the court in Campbell v. State, the case I mentioned earlier, says that ordinary inquiries incident to a traffic stop include the check in driver's license, determining whether there are outstanding warrants against the driver, and checking out the registration and the proof of insurance of the car. Sergeant Savoy did exactly what the law allows him to do. When the defendant wasn't able to produce his driver's license, he didn't just stop there and arrest him. He asked him for his name. He received the name. He said Jarvis Dorch. And then Sergeant Savoy went to his car, and we saw it as he checked his computer to find out if that name corresponded to a photo that would resemble the defendant. And as we all have noticed, it was totally different. And it took Sergeant Savoy several steps and several efforts before he was able to finally figure out what the name was. Once he figured what the name was, he also discovered that the defendant did not have a valid driver's license. I think it is very, very clear that everything that Sergeant Savoy did in this particular case did not violate any of the defendant's constitutional rights. He was driving a motor vehicle. He testified that he, based on his specific training and experience on estimating the speed of cars, he estimated that he was speeding at least 10 miles an hour over the speed limit. He mentioned all the other indicators that allowed him to determine that this defendant was speeding. One was that he would overtake passing other cars that were going basically at the speed limit. And obviously, if the defendant was passing those cars that were driving at the speed limit, he was speeding. He also said that he paced them. He's very well trained in pacing a motor vehicle and therefore estimating the speed. The reason for the stop, therefore, was valid. He had the right to investigate whether or not this defendant was driving the vehicle with a valid driver's license and if there were outstanding warrants. He did that, and he found out that he did not have a valid driver's license, and then he proceeded to, tow the car subsequently. For those reasons, Your Honor, the state asked the court to deny the motion to suppress.
I would agree with Ms. Leon that the White case is distinguishable, as it was a consensual encounter between a law enforcement officer and a drunk citizen. What we have here in this case is a traffic infraction, which is a next step up to an investigative stop. So there is that difference. My argument is that there was no well-founded suspicion, reasonable suspicion, or probable cause to conduct a stop at all. In Florida, we know police can initiate a traffic stop if they have reasonable suspicion that a crime has been, is being, or is about to be committed, which does include traffic violations, like speeding, running a red light, running a stop sign. The standard when you judge these type of situation requires more than just a mere hunch. It's not quite as much as probable cause, but it requires more than just a mere hunch. And the problem I have with all of these cases that we deal with, when there's this type of, you were speeding, you ran the stop sign, you didn't come to a complete stop, we're getting into areas now where law enforcement officers do not have cameras in their car anymore. They don't turn their body cameras on until after the stop has occurred, until they're approaching the vehicle. So we're going down a road where we never know if an officer is telling the truth about whether or not they were speeding or whether or not they're just going to say they were speeding. And you have to have some type of articulable facts or rational inferences to justify pulling somebody over for a traffic infraction. And just saying that you paced them, I'm going to argue, isn't sufficient because we don't really know if that occurred. If we continue to allow law enforcement officers to tell people they were speeding without having some type of proof to justify why they stopped them, they're going to remove all cameras from their cars. They're never going to have cameras, or not going to turn their body cameras on to verify that they actually did pace them speeding at 45 miles an hour, 35 mile per hour zone. Then it's always going to be just the cop's word against nobody else's word because nobody else saw it. My argument is this was an illegal stop because we don't have articulable, objectifiable facts that prove or indicate that Mr. Thomas was really speeding. All we have is the officer's word for it. And I know in past courts say that's good enough, but we're getting to the point with all the undercover narcotics officers cruising around on the highways, pulling people over for different things. There's never any proof that that's actually what happened. And my argument is if we're going to continue down this road, they need to be able to verify that he did actually clock him, he did actually follow him, And his speedometer did say that he was going 45 miles an hour. And without that, a body camera, some type of video, I argue that the stop is illegal. This wasn't a stop for speeding.
Wait, say that again. You're saying the stop's illegal if he doesn't record that portion of it?
That's what I'm arguing, yes, sir.
I don't think the law says that, Mr.
It's
Cobb.
his word and nobody else's word. The law says he has to have an articulable, reasonable explanation that proves that this is what happened. And they can say whatever they want. And where does that put defendants? How does the defendant prove that what they said is actually true? We can't. Defendants cannot fight it. We're just stuck with the fact that a cop said this is what happened, we have to deal with it. It's the only place in our criminal justice system where a defendant can't fight back without some type of objectifiable proof that what the cop said is actually true. And so, yes, sir, I am arguing that we've come past the point to where it's time to make officers back up what they're stating in these type of traffic stops. The Supreme Court's already gutted us with regards to protectual stops. Defense counsel cannot argue anymore that this stop was protectual. He wanted to initiate a drug stop, so he came up with a traffic violation. The Supreme Court said it doesn't really matter what the officer's intent was. Well, if we're going to continue down that road where pretext doesn't matter anymore, for heaven's sakes, we have to make the officers be able to prove that why they actually stopped them is valid. And we're not at that point. That doesn't happen in any courts. The courts routinely just take the officer's word for it. And I'm saying that we have to stop that. And that's my argument, that this stop was illegal based on what I've said here today. Now, when he got out of the car, this officer had already made his mind up that he wasn't going to give him a speeding ticket. So was he stopping for speeding? And when he says, I'm not going to give you a ticket, isn't he abandoning the whole reason for the stop? He's abandoned his whole purpose for why he's stopping him. And he could say, you just got to slow it down, Mr. Thomas, have a nice day. So those are my arguments. I think the stop wasn't legal. I think the officer did not have reasonable suspicion or probable cause that Mr. Thomas was speeding. I think this was a pretextual stop, but the Supreme Court's pretty much gutted that argument. And the only way we can verify this is if we do have in-car videos to prove that he did actually pace him. That's my argument.
Any rebuttal to that, Ms. Leone?
Just a couple of... I'm going to address first the last point that he made, that the officer decided not to issue a traffic ticket, and Rodriguez versus U.S. states precisely that beyond determining whether to issue a traffic ticket, an officer's mission includes ordinary inquiries incident to the traffic stop to ensure that vehicles on the road are operated safely and responsibly. Typically, such inquiries involve checking the driver's license, determining whether there are outstanding warrants against the driver, and inspecting the automobile's registration and proof of insurance. What Sergeant Savoy testified to about the reason for stopping, he articulated precisely, Your Honor, what he observed, how long he paced them, what the driving pattern, the fact that he was overtaking other vehicles, therefore indicating that he was going faster. Also, he explained extensively his specialized training in exactly estimating the speed of cars to the point that now he's just passing some tests to be able to teach it to other officers. Based on defense's counsel argument, the only reason to find that the stop wasn't valid is to find that Sergeant Savoy lied about the stop. There is no requirement, as the court knows, about having certain equipment on the automobile for law enforcement, such as in-car video or even body camera. We know that, for example, state troopers only have in-car videos, don't have body cameras. Sheriff's Office and Crestview Police Department only have body camera and not in-car videos. Your Honor, for those reasons, because obviously Sergeant Savoy was not lying about these actions and what he observed the defendant doing, he did everything according to the law and what the Constitution requires of him without violating the suspect's rights. The motion should be denied.
All right, a few things. I may have a question for the lawyers as far as to kind of see what their issue is with a particular concern of mine. But to start off with, and I know this just came up in an argument that in front of me last week regarding body cameras. There is no law requiring body cameras or car cameras. The relevant law is Florida Statute 943.1718, which simply talks about if an agency is going to use body cameras, they have to have certain policies that explain how they're to be used, when they're supposed to be used, that sort of thing. And a violation of said policy could potentially be some sort of bad faith by an officer. Arguing what basically the law should be is not something that the court's going to entertain. I think for me to say, you know what, I disagree with what the law is, this is what it should be, so I'm going to rule that way, I think is pretty much the definition of being an activist judge and trying to make the law myself as opposed to interpreting it. So I'm not going to take the invitation to do that either. I also want to kind of start off this portion of what I'm going to say is, in no circumstance does a defendant have to prove anything in a criminal case. It has a right to remain silent, doesn't have to present anything. However, when evidence is presented and it's unrebutted, then that's the evidence that the court has to interpret and apply to apply the law to. The facts in this particular case are that Sergeant Savoy observed the vehicle driving over the posted speed limit, both on his visual estimate and on by pacing. Also testified that the car was overtaking other vehicles, seemingly indicated it was going faster than the rest of traffic, and that's what kind of brought this vehicle to his attention. So I don't have any issue with the initial traffic stop. I think an officer stating not just he was speeding so I pulled him over, but gave the exact information as to why he thought that, how he was able to determine that, the two different ways that he was able to determine that. I mean, frankly, although you can't give a ticket 5 over or less, you can still be pulled over for doing 2 over. And I think the important part of the next portion of it is, according to the video, Sergeant Savoy said, "I'm not going to give you a ticket." But his testimony today was, "I can give you a warning, I can give you a written warning." So to do that, he has to check someone's driver's license, right? He can ask for registration, proof of insurance, as he's doing just a warning. But, and this is the question that I have for the parties, because I don't think it really got brought up, but it was something that was in my head during the course of the hearing. If there's a valid traffic stop and the driver of the vehicle doesn't have his driver's license on his person or in the car, isn't that a citable offense?
It is a citable offense.
So, I'm guessing you don't disagree with that?
I don't.
So, if someone doesn't have their driver's license, at that point, in order to give that ticket, potentially, of driving without even if it's a valid license, that you're driving without a license on your person, and then usually what they can do is go down to the clerk's office, I think it's pay $10, and the case gets dismissed, right? But it's still a citable offense for not having it on your person. So once that's the driver of the vehicle, who hasn't been identified at that point, says, "I don't have my driver's license on me," that is enough reason he can pursue the issue of potentially that ticket as well. So we saw clearly on the video that Sergeant Savoy was trying to figure it out, asked Mr. Thomas numerous times, trying to verify his name, and ultimately determined that he had given a false name, which, again, at that point, it becomes a criminal case for giving a false name. And I think that's kind of the extent of where this motion stops as to was there a proper traffic stop? Was there a reason to pursue these things, did it go too far in time past what can be allowed for writing a ticket? I mean, we stopped in 10 minutes into the video, 11 minutes into the video. I'm well aware of the case law that, there's no necessarily bright line rule, but for the most part, I think the case law talks about 15 minutes or so is kind of a upper limit of how long you can hold someone to write them a ticket, unless there's certainly different circumstances. Doesn't mean you get a full 15 minutes. If the ticket's written in 5 minutes, that doesn't mean you get to hold them for another 10. But in this particular situation, the way I saw it was valid traffic stop for speeding, both by pacing and by observation of a trained officer who's not only trained to estimate speed, but has actually become an instructor on how to teach others to do so. And once he asks for a driver's license and he says he doesn't have one, I think he's free to pursue, again, writing the warning or the ticket for not having your license on your person while you're driving a motor vehicle. And so at that point, I think for the purposes of this motion, Sergeant Savoy hasn't done anything that I would see that would suppress evidence at this point. So I'm going to deny the motion.
When does this case sit on the next docket, Judge?
I would guess it's going to be on October 29th at 9 o'clock for the next pretrial conference.
May I approach Madam Clerk with the exhibit?
Yes, please.
No objection to that being introduced. I think I've already mentioned that.
It's already been admitted. It just has to be given in. All right. Anything else for Mr. Thomas?
No, sir.
No, Your Honor.
Not this time.
I believe we've got a couple other cases to take care of.
No.